Any mention?
Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 22.
20?
22. Your Lordship, I'm praying for 1 week's time to file the additional affidavit in this matter.
You have objection?
No objection, Your Lordship.
22?
22, Your Lordship.
Bararing Baman?
Yes, Your Lordship.
It's 1 week's time. That's paid by the council for respondent number. It's the respondent number.
For all the respondents, Your Lordship.
Okay, for respondents. Yes.
Your Lordship, similar prayer for items 17 and 18.
What 17, 18?
Your
What's the
Lordship,
matter
it's a promotion matter, Your Lordship.
Education Department.
There's some urgency.
1 week.
1 week's time, Your Lordship.
Why is 2020 matters listed here before this court?
Your Lordship,
been recused by
was
Oh, both
recused.
recused by my brothers. Yes. When? 1 week?
1 week, Your Lordship.
Okay.
Obliged, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 25.
25.
Yes, Your Lordship.
No objection.
1 week time, Your Lordship.
2 weeks.
What should it?
Yes.
Please, Your Lordship. Item number 22, Your Lordship, 1920 and 2324 on behalf of Mr. H. Abraham, I'm mentioning because due to some personal difficulty, he is absent today.
He's absent today. I saw him walking the road just now when I was coming to court.
I do. But
He even waved to me also. In full black uniform.
he informed me, Your Lordship. I'm so sorry. I was informed over phone that please make mention.
You know, I have a dashboard camera in my
Yes,
car.
yes, Your Lordship.
Yes, at least I can just get that extracted and play it for all lawyers to see.
And I informed petitioner's counsel also.
Very smart. 1920, which one?
Yes, Your Lordship. Contempt matter 1920 and 2324 connected matters.
Yes. Due to personal difficulty, yes. 1920, 23, 24.
Yes, Your Lordship. I'm sorry, Your Lordship, because
What
I was
are you sorry
informed.
about? Why should you be sorry? You're doing your job as your friend.
Wait, please, Lordship, I beg to mention this item number 21, Lordship. Lordship, this matter can come up after 2 weeks, Lordship.
Why?
Lordship, some difficulty is there, Lordship, today. 2 weeks, Lordship.
Yes.
Deeply obliged, Lordship.
You took consent?
Lordship, I'll inform them, Lordship.
No.
I called them, Lordship, today morning. They didn't answer, Lordship.
Until they come. Let us call her later on. Yes.
Lordship.
Daily list item number 1.
Lordship, may it please Your Lordship, in this matter we had preferred an SLP in the Supreme Court. Lordship, we have certain instructions. If the matter could kindly come up tomorrow, Lordship.
What are the instructions?
I'll need a copy of the order, Lordship.
Will be dismissed or still now Supreme Court on vacations?
Lordship, let it come if it can come tomorrow, Lordship, because I'll need the order in hand.
Yes, MSNG Inshallah appearing for the sole respondent.
Yes, Your Lordship.
Pray for some accommodation list after 1 week. Yes.
Much obliged, Your Lordship.
Item number 2.
What happened to the matter before the division bench?
Division bench, the appeal is pending. It's fixed for final hearing.
You comply, meanwhile. Why not comply?
Okay, that will be difficult to undo, my lord.
Difficult undo meaning?
It's a case of regulation.
We understand that these people were this
But
nectar,
they are
right?
in service, my lord. They are drawing their pay, my lord.
This order is, well, it's almost more than almost a year now.
Whether appeal will see any closure soon?
Not yet, well,
And which is it
well, it's,
in the final stage of
I'm sorry.
disposal?
I'm sorry,
The
well,
appeal is final stage of
well,
disposal or still
it's
in the
paper books have been directed, well, so I think in June probably we'll have a.
in service? Let's see. Otherwise, after 3 weeks.
Huh?
Cleared by the council for the respondent list matter of 3 weeks.
2, 3, and 4.
2, 3, and 4 all connected matters, well, so I'll agree.
Item number 5.
May it please your lordship. Your lordship, in this
Rejoinder
matter,
file.
yes, we won't be filing a rejoinder, your lordship.
GC Marbo, I with you in this case.
Yes, your lordship, she is my colleague. Your lordship, in this case, your lordship, if I may take your lordship to the affidavit in opposition filed by the respondent, your lordship,
Well, let come for hearing then.
because
Now what you got? Can
they-
be disposed of
yes,
now
your
only?
lordship.
What affidavit? What did he say?
My lord, I thought it's for rejoinder, but I didn't go. I thought it's for rejoinder, but I didn't go through the file.
If I may take your lordship to page 19, your lordship, of the
Page?
affidavit. Page 19.
Yes.
Point 24, your lordship. The deponent has submitted that the case of the release of family pension in favor of the petitioner is under process at the CPAO, New Delhi, at advanced stage and held up for one half of the PPO and LPC certificate in respect of the deceased husband of the petitioner, which is yet to be received from the.
Yes, Dr. Mozika.
Yes.
That means it's a small hitch only.
There are some instructions, my lord. I didn't prepare this case, my lord. If the matter come tomorrow, day after tomorrow, my lord.
Because it's a pension matter. Yes. They come there tomorrow. Because MSRS Khashiyang has submitted that no rejoinder be necessary in view of the averments made in para 24 of the affidavit opposition filed by the respondents 1, 2, 3, and 4. This is the matter from further orders. Kindly see if that's only hitch, then instead of hearing it, it can be disposed of.
6.
May it please your lordship. Your lordship, in this matter, I prayed for 2 weeks' time to file the rejoinder.
Yes. You already prayed. How many times you prayed rejoinder?
Might be.
Don't know. Who's father side? H. Kharmi. Where's Kharmi?
I'll appear for today,
The
lordship.
matter is dealing this for the 2 weeks as prayed. Lord, for your name.
Apply, lordship.
7.
May I please your lordship? In this matter, I'm appearing on behalf of respondent number 8 and I'll be filing my affidavit in opposition in the course of the day, your lordship.
Rejoinder, the other affidavit.
Rejoinder, I'll file together one day.
MS Khashiyang for R8.
Respondent 1 to 6 of all.
Respondent
I'll
will
file
file
together.
what's the day. Just after
For rejoinder.
2 weeks for rejoinder, if any.
Pleasure.
8.
May I please your lordship? In this matter, I pray for some more times, your lordship.
Yes. How many times you prayed rejoinder?
Only once, your lordship.
Okay, I've prayed for the 2 weeks time allowed for rejoinder. Yes.
Much obliged, lordship.
9.
My lord, in this matter, rejoinder will not be required, my lord. It's only a question of law involved. Where during
What's the matter come for the bench? What's the matter about?
my lord, this relates to my lord, consideration for promotion. There's a DP pending.
Why did it go to the other bench then?
Just for one date, my lord.
Oh,
Will come for hearing, your lordship. We have filed if you
party submit please are complete. Just a matter for hearing on so and so.
Deeply, Lordship.
10,
May it please the Lordship. Lordship, item 10 and 11, Your Lordship, are analogous matter, Your Lordship.
The state was supposed to place instructions as to what steps they've taken, my lords. I draw your lordship's attention to the order dated 8/5/25.
Just a minute, please.
Yes. What steps have you taken?
Lordship, may it please your Lordship. Lordship, instruction has been issued to the district school education officer, Your Lordship, to issue show cause notices, Your Lordship, to the managing committee, Your Lordship.
So is it correct, Mr. Paul, infructuous now?
I'm sorry, my lords.
Infructuous is a matter now.
Well, as I had submitted on the last occasion also, in view of that inquiry report, I had only prayed this matter be kept pending so that something actually moves forward.
Yeah, communication has been produced for the court. This court dated what? I can't
This is
see the
13
date.
May, Your Lordship, 13/5, Your Lordship.
13/5, wherein steps which indicates that certain steps have been taken, such as issuance of show cause notices to the managing committee. This stop the same has been made as per submission pursuant to inquiry report, that has been since furnished.
Today's
The regard of the complaints against the managing committee members of Rajawala Higher Secondary School, West Garam and stuff. Though it is submitted by learned AAG, the matter has been rendered infructuous in view of the steps that will be taken by state respondents, Mr. K. Paul and Senior Counsel praise the matter be kept pending. We'll keep it pending for another 6 weeks.
Then let it come after 4 weeks, Your Lordship.
Because well, this letter is dated the 13th. They say your reply is to be within 14 days. That would have been 27th.
Yes, at least a matter of 6 weeks.
Lordship, highly apply, Your Lordship.
Copy of the communication dated 13/5 taken on board, made part of the record. Yes.
Apply, Your Lordship.
Next matter is also connected.
Next matter also.
It's connected, my lords.
12,
Your Lordship, state has filed our affidavit yesterday. Your
What
Lordship,
about Mr. We are for 2, 4, and 5?
2, 4 and 5, Your Lordship, the affidavit
1 and
is
3?
filed.
2, 4, and 5. What about 6 to 8?
Mother 6 to 8 I'm present.
You won't file?
Mother, the only difficulty is I'm not able to serve copy to the other side. Mother. I have been
serve now?
I've already, her colleague must have received, Mother, I have requested. So for that reason, Mother, my affidavit has been
We file it today then.
Mother, yes.
Your Lordship,
What about 10?
Then I already filed, Your Lordship, Mr.
Mother,
PD.
the only issue in this case, the matter has been sent
sent
to the
for reference,
court
Your Lordship.
in the month of March. Yes, my lord. So, my lord,
That's correct.
I have
and
no
the letter
instruction
has been
regarding
marked to
that.
the petitioner itself.
Let me
Those
seek
have been
instruction, Your Lordship.
It is in part of the affidavit.
Your
of the
Lordship,
state
if Your Lordship has my affidavit that I filed yesterday, Your
We
Lordship, on
received the
behalf of
affidavit yesterday, Your
respondent
Lordship.
number
I may be
5.
allowed
Okay,
sometimes.
this is a matter of parties, MS, Dr. M. Mozika for 1 and 3, MSZE, non-convened for 2, 4, and 5. Arco submits that, and who has 10? Not here. Submit that after since been filed. Stop MS Arc only for 6 to 8. Submit that after the final course of the day. Stop. It is also submitted next para by the London by MSZE, nominee Leonard GA, that the matters been since been in the reference court, and this has been stated on the affidavit itself.
Yes, Your Lordship.
Stop. MS Bison praised the matter to be taken up after 1 week to be able to obtain specific instructions. Yes.
Obliged, Your Lordship.
13,
May it please, Your Lordship.
Your Lordship, we have already filed an additional affidavit to bring on record the order dated 4/4/2025, Lordship.
Which one?
additional affidavit to bring on record the order dated 4/4/2025, Your Lordship, which passed by the District Council Court, Your Lordship, for rectification of the name of the parties.
Lordship will file the affidavit on
Today?
next week, Your Lordship. Next week.
After 2 weeks, Lordship.
1 week, MSLD, Sangma submits that the affidavit placed on record an order dated 4/4/2025 issued by the respondents 1 and 2 has since been filed. Today, MS Idahar and MS GCH Marak Pray for allowed for the 2 weeks time to file affidavits. Just for 2 weeks, yes.
14.
This case, Your Lordship, we've received the rejoinder yesterday, Your Lordship. May be fixed for
What's the
hearing.
matter about?
No, this is appointment, my lord, recruitment to the post of lecturer in Deficit College, my lord.
Having exceeded his age limit, Your Lordship, the government hasn't approved his appointment, which is why
Which we are
But
saying-
some development, they say that there should be age limit, there should be no cap. It takes many years for these people to qualify themselves. Anyway,
we'll examine that.
Next week, my lord.
Party submit please complete this matter for hearing after 1 week.
Deeply.
Pleasure, Lordship.
15.
Well, it's granted us some time to file a rejoinder affidavit. Well, it's to the counter affidavit filed by
But
the state.
it's rejoinder affidavit.
Well, it's.
They have sought time to.
I was supposed to file a rejoinder,
Yeah,
but we've
but
not
one
been
more
able to
thing is that this society is also not registered. There is no. I have received a letter.
It's a Meghalaya Medical Association.
Yes, my lord. We have received a letter informing
Let them file it by way of an affidavit, my lords. We'll respond.
No. First, you file the rejoinder.
I'll file my
File
rejoinder.
rejoinder.
If there's any new issue, my lords, they have to.
They don't
bring it
interim
up.
orders operating.
No.
There is no interim.
Yes, Mr. K. Paul prays for the 2 week time to file rejoinder. List thereafter and so on.
16.
Please, Lordship. Lordship, I have received the affidavit filed by the respondents. It's regarding payment of the dues to the petitioner who was the legal counsel.
Received. MS Agarwal, Dr. Agarwal, have you paid the dues? Can't hear you. You're not audible. You're not audible. Yes.
I think her mic is muted.
Your mic is muted, yes. What happened?
Lordship, they have filed an affidavit. Lordship, the bill was around 1,78,000. They have sanctioned around 1,20,000. So, Lordship, it's not clear as to why they have suddenly now, 3 years down the line, they have sanctioned half or 70% of the amount. Whereas they don't they're not disputing the bill, Lordship. It's as per their memorandum only, the bill which has been made. It's not.
What's happened to her? Something wrong with the.
It may be taken up on some other day.
Yes, after 1 week, yes.
Affidavit has been filed.
For clarification.
Obliged.
Yeah. From the side of the UGC respondents.
Supplementary list, item number 1.
One thing, where's Mr. Paul?
Lordship, he's in the premises. He's coming, Lordship.
Only one thing again which the court needs, that's why it's not an arbitrable dispute. That's the only thing, that's only that part I mean. The only submission been made is that they are de-affiliated, they've been de-affiliated, so they will not be covered by arbitration clause, correct?
Lordship.
That's the only ground.
Lordship, it is not an
No
arbitrable
other
dispute.
submissions to make on that.
Lordship, we do have submissions, Lordship.
On the, why is this not an arbitrable dispute?
Lordship.
What's happening, Mr. Paul?
Lordship,
Want
if
a cup
this,
of tea?
Lordship, if this matter may come up after some time, Lordship.
Yes, we'll take up one of matters first.
Highly obliged, Lordship.
Hearing the meeting. See, we are both of list. Because we'll finish this matter today, Mr. Chandri, so we won't keep it. Yes.
Item number 2.
Number 2, the order says.
My lord, this relates to land acquisition for border fencing. 2, 3, 4 connected petitions are there, my lord. 3, 4 writ petitions are there.
Yes, 416.
My lord, if lordship permits me, matter may be taken up day after tomorrow. I have some difficulties.
What difficulties, Mr. Chandri?
My lord, I'm unable to look at the record today.
Oh, you prepare for other matter.
Lord, this is a matter relating to
day after tomorrow.
That border fencing.
Border fencing, Miller. Only issue is that border fencing can go on because whatever claim they have, they can do it before the officer under the Land Acquisition Act, judicial officer, because that issue is also, my lord, the section 72 is very clear, my lord, and identical matter came in Andhra Pradesh in Kerala High Court, my lord, where the dispute was and the matter was referred, my lord, because we are facing problem. I just wanted to click the ruling. This.
You kindly, you give the copy of the judgment to the Senate Council.
I will cite only the statutory provision, my lord. This is only quoting statutory provision. For the purpose, your lordship will see paragraph.
There's no border fencing in Kerala.
Yes, your lordship will see page 7.
Page 7, yes.
Filed before reference authority.
Order communicated, yes.
Yes, the issue is that if your lordship will see the submissions and everything, my lord, but only thing direction, similar direction, we order this petition to the limited extent of leaving liberty to the prisoners to invoke and pursue their statutory remedies under section 64. And 2 weeks from the date of receipt of copy, judgment third party district collector, who is the company, shall place the file before reference authority, who will take a decision after hearing the prisoner as well, so and so, culminating appropriate order. So all these matters, my lord, 71, and the matters can go to the reference authority, my lord, and they can adjudicate who is entitled to compensation, my lord, and therefore, my lord, to that limited extent only, my lord, I wanted clarification. I have no issue. No quarrel with their claim or
We'll be here next week.
Your lordship, next week we can have it, my lord, but only that
Monday.
Tuesday, your lordship,
Yes.
Tuesday,
Yes.
Tuesday. Border fencing, your lordship, so far as border fencing be allowed, my lord, that because we are not,
of course.
so that to that extent, your
We'll
lordship,
examine this judgment, but then
yes,
otherwise why should we be held up?
yes, my lord, that is the trouble we are having, my lord.
Yes, can I get 2,
3, 4.
I do 2, 3, 4 list on
2 to 4, my lord.
2 to 4 is a fixed
2 to 4.
matter. Yes. Tuesday is third.
And your lordship, in the meantime, border fencing may go on. There is because
your lordship, we will address.
Your lordship may clarify because the hearing and the decision.
We are challenging the acquisition itself.
List these items.
Only one matter. Some
3/6.
Yes.
2025. Stop. The urgency. Urgency has been expressed by the Advocate General, who submits that, notwithstanding any other disputes that the landowners might have, the border fencing may be allowed to go on. Yes. This according. Yes, Mr. Pascal. What do you have to say?
Lordship, I am appearing for respondent number 12
Yes.
in item number 3.
Yes. Right. Record his presence.
Friday, I am having difficulty. Tomorrow, your lordship may have it tomorrow. Tomorrow, it's only 1-2 sections I have to show, my lord.
I have some difficulty, my lord.
Your lordships have made it clear, my lord, just that today will be the date for final hearing. So I am requesting my friend if he can accommodate tomorrow at any time.
I have one fixed method before the High Court, fixed method. Only because of that. Otherwise, Friday, my lord.
Friday I have one fixed matter in Guwahati. That is the problem.
On Monday, my lord. That is.
The court at the mercy of the senior consuls.
It will be fourth, your lordship. May have it Tuesday. Okay.
On fourth.
Fifth.
You just take a date.
Yes.
Which is convenient to all of you.
Yes, ma'am.
Instead of
holding the court.
Hearing item number 5.
Go first. No, Mr.
Second
Tony,
call.
can you
Second
yes,
call,
this
item
order
number
matter
1.
which no, we just finished order matter.
Number 6.
Number 1 is the supplementary list. Yes, where is he?
He's coming, sir. His lordship.
Yes, Embassy Cruz. Where's your senior?
Lordship, he is in the premises. Lordship, he's coming.
Mrs. No doubt, that's what you. I thought it sounds so. See, the thing is that yesterday, Mr. Paul has advanced arguments on the public law function of the IGU, and only one part. Oh yes. Anything to say about why it is not an arbitrable dispute?
Well, I submitted 2 things, Millets.
Yeah.
If I may just take your lordships back to that provision. We'll do it. Well, if I may read it at page 77, clause 66. It says, well, it's all unresolved disputes shall be settled by the...
1 second.
Well, of my writ petition, well,
Page 77.
It says, well, my lord's out.
Yeah.
Well, it's all unresolved disputes shall be settled by the Arbitration Commission of the Indian Olympic Association and all affiliated members of the IGU shall voluntarily surrender the right of seeking redress in a court of law. Now, the first issue is, my lords, that what I had submitted before your lordships, the admitted position is my affiliation has been cancelled. I am not affiliated. So, that second part of the provision, my lords, that...
Even then, that means that there's no dispute between you and IGU. Even if you are disaffiliated, but then is that not a dispute?
I'm sorry, my lords.
Is that not a dispute?
My lords, disaffiliation, my lords, disaffiliation is the final action. If what I had submitted before your lordships yesterday, my lords, is that if IGU had in the first place, my lords, issued a notice to me saying that you do not meet these criteria, and I had responded saying, my lords, that no, I have this criteria, then a dispute arises. Then it becomes a live dispute. As your lordships would recollect, I had submitted before your lordships that then it's a live dispute, which then can be resolved by arbitration. Just for the sake of argument, my lords, I'm saying it. I'm not conceding to that. But here is a case, my lords, where they do not raise a dispute, they finally pass a final order. Without following any of the principles of natural justice, my lords, they go ahead and they pass a final order, de-affiliating me. So there is no dispute as on today.
That means there's no record.
I'm out. I'm out. I don't come within the 4 corners of clause 66. If there is a dispute, has to be there. A dispute, essentially, as your lordships would understand, is one party making a claim and the other party refuting the claim. And then, my lords, it goes to a third party who is to then adjudicate the claim. In this case, my lords, there is no dispute. They do not say that A, B, C, D. Tell us.
There is a dispute, but not an arbitrable dispute.
It's not an arbitrable dispute.
That's your
my lords, I say it's not an arbitrable dispute.
Okay.
At 2 authorities, my lords, I'll very quickly place. I wanted to place it yesterday. Just give me the... You have copies for the court? Well, it's one judgment of the Honorable Supreme Court. It's 1988 2 SCC, Mallards, page 338. We had no copies yesterday.
1988
2 SCC, page 338, Mallards. This is Major Retired Inder Singh Rekhi versus Delhi Development Authority.
Yes.
If my lords kindly look at paragraph 4 at page 340.
Yes.
Therefore, in order to be entitled to order of reference under section 20, it is necessary that there should be an arbitration agreement, and secondly, difference must arise as to which this agreement applied. In this instant case, there is no dispute that there was an arbitration agreement. There has been an assertion of claim by the appellant and silence as well as refusal in respect of the same by the respondent. Therefore, a dispute has arisen regarding non-payment of the alleged dues of the appellant. The question for the present case, when did such dispute arise? The High Court proceeded on the basis that the work was completed on so-so. My lords, we'll skip all that. But in order to ask for a reference under section 20 of the Act, there must not only be an entitlement to money, but there must be a difference or dispute must arise. What I submitted before Lordship is there has to be a claim or there has to be a refutal by my side. When there is a difference of opinion
that,
by
but
two persons.
In your case, is that you were affiliated to the IGU, correct?
I was.
Now, one fine day,
I am de-affiliated.
They pass on order saying de-affiliated, and they recognize Mr. Dongbri's client as the the affiliated body for the
golf in Meghalaya.
In Meghalaya, right? Now, can't that be arbitrable in the sense that it is a dispute? It's unresolved.
Had the final order not been passed, then yes, it would have been a dispute.
That is a
it culminates. Well, it's like this. A trial will precede a sentence.
So we understand that, of course.
If a sentence is passed, well, there is no point of a trial. Because what essentially happens...
Can be enlarged the scope, by interpretation. That, there's a dispute that is unresolved. In the sense that, even notwithstanding the orders will pass against you, de-affiliating you, it's a dispute that has arisen because of the disaffiliation. Before that, there's no dispute.
There was no dispute. It is a dispute, but it is not it does not continue to be an unresolved dispute. They chose to resolve it in a certain way.
This is a dead issue.
That's a dead issue. And therefore, I say, the second part of it comes into play, where I say, that they say that affiliated members surrender their right to go before a court.
So being disaffiliated, that means...
The moment I am disaffiliated, that condition does not apply to me.
Okay.
So, which is why I say, it is not an arbitrable dispute and it is not a live dispute.
We know that is not arbitrable. Isn't that the decision?
Now, this issue, has again been taken up, this 1988 matter, has again taken up in 2024, 5 SCC, page 358.
So, especially it's only a claim and denial.
There has to be a claim and there has to be a denial. Now, the relevant paragraphs would be 36, 37 and 38.
(37),
36, 37, 38, my lords, page 373, if my lords can I have a look.
Yes.
Well, this is a more recent judgment. It says, in Inder Singh Rekhi versus DDA, it has been held that the existence of a dispute is essential for the appointment of an arbitrator under Section 8 of a reference under Section 20 of the Arbitration Act. And the dispute can arise only when a claim is asserted by one party and denied by the other on whatever grounds. Mere failure or inaction to pay does not lead to inference about existence of a dispute, as expression dispute contains a positive element of assertion, and in denying and merely in an inaction to accede to a claim or a request. With respect to the period of time, we'll skip this if your lordships kindly come to page parrot 37. For a proper understanding of the ratio in the aforesaid judgment in Inder Singh Rekhi, we reproduce para 4 of the judgment in its entirety, what I had read before your lordships. And it's 38. 3 principles of law are discernible from the aforesaid decision in Inder Singh Rekhi of this court. Firstly, ordinarily on completion of the work on right of receive the payment begins. Secondly, a dispute arises when there is a claim on one side and its denial repudiation by the other. And thirdly, a person cannot postpone the accrual of cause of action by repeatedly writing letters. Third is not relevant for us, my lords. 2 is relevant for us. There has to be a claim, and, my lords, there has to be a denial. Which is why I submitted before your lordships, my lords, that if they had issued a show cause notice to me and I had denied it, probably then this argument could have been pressed into service that under 66, your remedy lies before arbitration. They chose not to do that. They chose to pass a final order.
Okay. Yes, we'll hear Charis. I think that's it.
Well, it's
yes, Mr. Charis.
Briefly, I'll give my rejoinder. The 2 days submission by my learned friend yesterday and day before yesterday. Now, the issue here is, my lord, whether the appellation action taken by the IGU amounts to public function or not.
Yes, that's the first.
That's the
first argument is the public function and whether
yes.
And
second is about the
yes.
arbitration clause.
Yes.
Now, with regard to the first one, the learned friend tried to justify that number one, since it is recognized by the Union of India, so read lies. My humble submission to that is, my lord, recognition given by the Union of India is as a policy matter. Is a policy recognition. There is no statutory recognition given to all the federations, including the IGU. Merely giving me recognition doesn't mean that all my actions amounts to public function. That is absolutely wrong. Absolutely wrong. Second issue, my lord, he refers to aims and objectives to identify me that my action is amounts to public functions. My aims and objectives may be my lofty, but the here issue the lordship is dealing with is affiliation. The affiliation process amounts to performing public functions or public duty or not. Therefore, the aims and object has nothing to do with the action taken by me with regard to my relationship between the state level federation and the IGU. And the third, my lord, my friend has referred to Pini decision, and he says that once decision is final and binding to society, that amounts to public function. Now, Pini case also, when we see properly, my lord, there was a company terminates the employees, saying that the service condition arising from the contract. So, Supreme Court did not interfere that termination. My humble submission, my lord, the Pini judgment laid down the proposition of private authority can discharge public functions. That is undisputed. I never submit that, my lord, IGU, like PCCI, never perform public functions. There are some, my lord, my actions like PCCI may amounts to public function, public duty. But with regard to the affiliation,
it's a total.
It is
it's a
purely,
function
my lord,
of the of the union.
My lord, severance of ties between me and the state federation is governed by the bylaws. This bilateral relationship has nothing to do with the public. For example, my friend one day come saying that I will withdraw my affiliation. I don't want to affiliate with you. How it affects the public? It doesn't affect. It is my relationship between he and me only. It is purely governed by the contract between the two. So if there is a breach of contract, therefore because of them, arbitration clause comes into being. So therefore, my lord, the Pini judgment never says that decision taken by the authority binding and final amounts to public function is not correct, my lord. Here, till then, my lord, my learned friend, unable to justify how the affiliation action taken by me amounts to public duty. Now, my friend has referred to Manipur High Court. Manipur High Court, we have gone through, my lord. 3 issues involved, my lord. The society was dissolved. That was registered under Manipur Society Registration Act. Resulted to the affiliation and resulted to formation of ad hoc committee. Now, the fencing association take the plea of non-maintainability, but they never take the plea of alternative remedy. Now, the Manipur High Court entertained that one and say interfere with the action. Now, the same matter, my lord, the Indian Fencing Association in Madras High Court, Learned Division Bench of Madras High Court, clearly say that there is an arbitration clause in the body of the MOU in the bylaws of the fencing. Therefore, the action taken by the authority regarding any dispute should be addressed by the arbitration committee. My lord, may I just place that judgment, my lord?
Madras High Court.
Madras High Court, my lord. May I just please. And the settled position of law laid down by now, Honorable Apex Court has been referred to, my lord. I will not take the entire one. May I just straight away come to, my lord, para 5 onwards. Para 5 onwards. Her learned counsel appearing for the appellant and the learned counsel appearing for the respondents. The learned counsel appearing for the appellant contended that there is no unresolved dispute warranting invoking of arbitration clause. And on the other hand, what is under challenge is the suit is only the order of the first defendant appointing an ad hoc committee. Therefore, according to the learned counsel, the suit is maintainable. We are unable to agree with this submission for the following reason and discussions. The order on the appeal is the one rejecting the application filed by the plaintiff seeking for an order of interim injunction pending disposal of the suit for the relief of declaration and injunction as stated supra. In order to seek an interim injunction, first of all, the applicant plaintiff has to satisfy the maintainability of the very suit itself, especially when defendant number 1 to 5 have raised a preliminary objection with regard to maintainability of the suit in view of the presence of arbitration clause in the memorandum of association of the first respondent, first defendant. Admittedly, the memorandum of association of the first respondent, defendant contains in clauses such as all unresolved disputes arising within the State Fencing Association, Union Territory Fencing Association affiliated to Fencing Association of India shall be entered by the State Fencing Association, Union Territory Fencing Association to Fencing Association of India for settlement by the Fencing Association of India under the Arbitration Act. For this purpose, the Fencing Association of India shall elect a panel of arbitrators to be decided that the Fencing Association of India General Assembly at their annual general meeting of whom parties to the dispute in a state fencing association or Union Territory Fencing Association will select one arbitrator and the third arbitrator out of the said panel will be mutually agreed upon by the two arbitrators. The arbitration proceedings shall be completed within the period specified under the Arbitration Act or within the time extended by the arbitrators within the consent of the parties. It is important. All disputes between State Fencing Association, Union Territory Fencing Association.
So just holds that once there's an arbitration clause, it's mandatory that the parties have to, whether they will get relief under it or not, they have to resort to it first.
My lord. Lordship, can you see para 8?
Yes.
Referring to Apex Court. The Apex Court, in the decision report in such 2000, while considering the scope of Section 8 of the Arbitration Consideration Act, has observed that it is obligatory for the court to refer the parties for arbitration in terms of their arbitration. See, my lord. Arbitration agreement. Nothing contains to be decided in the ordinary action or the appeal arising therefrom. This decision has been subsequently referred to and followed by the Apex Court in its subsequent decision, 2003, which is relied on by the learned single judge. In the same line, the Apex Court in such 2006 has observed that when the judicial authority comes to know of the existence of an agreement, there is no question of the court under such act restraining the arbitrary proceedings from commencing or continuing, and that in fact Section 8 is intended to achieve, that is to say, the converse result. Thus, by considering the law laid down by the Apex Court, that the civil courts cannot entertain a suit in a matter where an arbitration clause is in existence, and that it is for the courts to refer the matter to arbitration proceedings and not to continue further, whereof the confirmed view that plaintiff appellant is not entitled to maintain the suit before this court. The learned single judge has rightly held that as the very suit is not maintainable, granting of interim order does not arise. Consequently, the order dismissing the said application does not warrant any difference. So the writ petition will also dismiss them. Well, my humble submission, therefore, is when the arbitration clause is there, my lord, it is a consent agreement. My lord, they came forward to affiliate me, knowing very well this condition. MOA also spell out that your rules and regulation of state level should conform with the IGU rules and regulations. It's a consensual agreement, my lord. Now, my learned friends say that there is no disputes. My lord, according to me, we issue a notice.
His submission is that there is no dispute. If a dispute arisen during the subsistence of the affiliation, yes, then he can go arbitration. But what has happened here is that why he's come to writ court is that there has been a sudden, a disaffiliation without him being heard, based on whatever considerations that the Indian Golf Union had.
Right.
Now he says that because of the action of the Indian Golf Union, which you have done, so that means it's not an arbitrable dispute, and that arbitration clause will be of no use.
Right.
Because it's not an unresolved dispute, it is it's already final. That's the only thing.
But according to him, my lord, my email notice may not be amounting to issue notice.
Yes.
But right or wrongly, my lord, according to me, it is a notice to all of them. My lord, if he has a grievance with that, he doesn't respond. He did not deny that one. He never said he did not receive. He did not respond. Secondly, I conducted inquiry. Any adverse inquiry is there. Acting upon that, I have taken decision and remove him. That amounts to a dispute. Now that squarely fall within the RR 66. Now who will decide whether it is an arbitrary dispute or not? I may just late one the Supreme Court decision. 2021. 2021 volume 2 SC page 1. Relevant para, my lord, may take note of para 30, 153, 154 and 154.3.
Just 1 second, sorry. 2021?
Madam. 2021 volume 2 SC page 1.
Yes, para.
Para, my lord, 130, 136, 153, 54 and 55. Now, my lord, may I take to the issue that was arose before the apex court. I just refer. My lord, may come to that running page 44 of the same judgment.
Where is that? 44.
44, page number 44.
You're referring to paragraph 130.
But before I go to,
you're going back.
Before I go to para, my lord, that para 130, may I just come to para 2.1, my lord.
Okay.
That is running page 44.
Okay. Yes.
My lord, 2.4. Meaning of non-arbitrability, and when the subject matter of the dispute is not capable of being resolved through arbitration. The conundrum, who decides whether the court at the reference stage or the arbitral tribunal in the arbitration proceeding would decide the question of non-arbitrability? Is a question involved. My lord, may come to 130. Wait, para 30, running page 109.
Yes.
My lord, it says, Section 16.1 of the Arbitration Act accepts and empowers the arbitral tribunal to rule on its own jurisdiction, including a ruling on the objections with respect to all aspects of non-arbitrability, including the validity of the arbitration agreement. A party opposing arbitration as per subsection 2 should raise the objection to jurisdiction of the tribunal before the arbitral tribunal, not later than the submission of statement of defense. However, participation in the appointment procedure or appointing an arbitrator would not preclude and prejudice any other from raising an objection to the jurisdiction. Obviously, the intent is to curtail, delay, and expedite appointment of the arbitral tribunal. The clause also indirectly accepts that the appointment of an arbitrator is different from an issue and question of a jurisdiction and non-arbitrability. As per subsection 3, any objection that the arbitral tribunal is exceeding the scope of its authority should be raised as soon as the matter arises. However, arbitral tribunal as per subsection 2 is empowered to admit a plea regarding lack of jurisdiction beyond the periods specified in subsection 2 and 3 if it considers that the delay is justified. As per the mandate of the subsection 5, when objection to the jurisdiction under subsection 2 and 3 are rejected, the arbitral tribunal can continue with the proceedings and pass the arbitration award. A party aggrieved is at liberty to file an application for setting aside such arbitral award under such of the Arbitration Act. Subsection 3 to section 8 in specific term permits an arbitral tribunal to continue with the arbitral proceedings and make an award, even when an application under subsection 1 to section 8 is pending consideration of the court forum. Therefore, a pendency of the judicial proceedings even before the court is not by itself a power for the arbitral tribunal to approach it and make an award. Whether the court should stay arbitral proceedings or appropriate defense by the arbitral tribunal are distinctly different aspects and not asked to elaborate in the present reference. My lord, may come to para 154, my lord. That is running page 121. 120, my lord.
154.
Para 153, my lord. Running page number, my lord. 120. The concluding part of the judgment.
Yes.
Accordingly, we hold that the existence of an arbitration agreement in Section 11 of the Arbitration Act would include aspect of validity of an arbitration agreement, albeit the court at the referral stage would apply the prima facie test on the basis of principles set out in this judgment. In cases of debatable and disputable facts and good reasonable arguable case, etc., the court would force the parties to abide by the arbitration agreement as the arbitral tribunal has primary jurisdiction and authority to decide the disputes, including the question of jurisdiction and non-arbitrability. Discussing under the heading, who decides arbitrability, can be crystallized as under, may come to 154.2, 54.3 straight away. The general rule and principle in view of the legislative mandate from Section 7 to 2009 and the principle of severability and competence is that arbitral tribunal is the preferred first authority to determine and decide all questions of non-arbitrability. The court has been conferred power of second look on aspects of non-arbitrability post to the award in terms of such. Now, my humble submission, my lord, this issue cannot be decided either by me or my friend. It can be decided by the authority. And the arbitration commission is there, not formed by me. It is formed by the Olympic Association. Impartial ombudsman is there to resolve the disputes between the federations or the affiliated federations. Therefore, the issue that it is non-arbitrable, therefore they can come straight away. This honorable court is not sustainable in law. This is my submission, and they respond. And other, my lord, he has referred yesterday my income. I will not take that paper.
Income?
The financial paper.
Financial assistance you
yes,
get from the government. Yeah.
My lord, what happened in this case, my lord? Central government grant assistance to all the federations, not for running of the administration of the federations.
You argued earlier, you said it's just a policy.
Yes.
It's not a statutory regulation or function. Yes.
Right. And these amounts received goes to the players.
Now, only one thing, Mr. Chani, so yesterday, if you remember correctly, it was argued that BCI judgment had, what do you call it, distinguished between public function and private function. I said public function is when BCCI selects the team, it affects all the federations. So when they select the team, it's national importance, so it performs public function. And even the government recognizes that BCCI alone has the authority to select the players who represent India in cricket, wherever they play. Now, Mr. Paul has said that even this Indian Golf Union exercises the same function, because they exercise function in the sense that they also select the team, and all the federations come under it. And so, similarly, what goes on in the federations is a federal structure, and so IGU discharges the same public function. That's one thing. But now you've said that selection team, this is not a question of team selection in this present case. That's your argument.
Yes.
It's a question of the disaffiliation, which is a private function of the IGU itself. So similarly, as in BCCI, is a private function. That means it's not amenable to jurisdiction. Whereas if it concerns, if the argument, if that's correct, if it concerns selection of players, so on and so forth, there will be a public function. That's the argument.
Like BCCI held the same thing. Therefore, my lord, here yesterday he has referred to the grants from the central government. Now, the grant we receive is purely for the promotion of the players.
Oh, yes, I forgot to add one thing. That you mean to say that the government has no pervasive control over the IGU?
Yes. Financially, functionally, as well as administratively.
What about the Ministry of Sports?
The guidelines
and youth affairs guidelines.
My lord, this is the policy guidelines. These are the policy guidelines govern to all the federations, my lord. Therefore, the Honorable Apex Court in the BCCI case held that this is merely regulatory exercise, control by the Union of India over those federations, my lord. There is no statutory controls, my lord. And this the mega assistance received by all the federations, it goes to the promotion of the players for their trainings, purchase of equipments, and for tournaments, my lord. It never goes to the administration of the federations. Therefore, the fund, my lord, we have sanctioned few amounts to the state level associations. That fund is for my own corpus. I never take from the central government, give to the state level federations. I generate my own fund.
The money you get from the government, what do you do with that? That is just for. That 1 crore some tournaments.
Yes. That is for tournaments and promotion of the players. And the amount we have given to the SGA.
So grants rather, not.
Yes, madam. Yes. The certain amount grants to the state SGAs is coming from my own fund, not from the central government. Not from the central government.
Yes.
So there is no financial control over me. And the same thing with the BCCI also, my lord. That point was already argued earlier also. and that issue arose. There is no financial control even to the BCCI. My lord. And with regard to RTI, my friend has referred to RTI yesterday.
What RTI?
The RTI, application of the RTI to all the sports federation, my lord. Now, these central government sanctions certain amounts for promotion of the players. My lord. For accountability, my lord, since they perform public functions like business and others, they issue a notification that you will be amenable, you will be applied. The RTI will be applied to you. My lord. That doesn't mean that my lord, application of RTI doesn't mean that all my activities amounts to public function. No. Or even KK69 case, my lord,
so even in the regard of RTI, you segregate, you distinguish the functions. Even there also.
My lord.
Even though you're bound to supply information.
Yes, yes. But it depends on the nature of the function we perform. Therefore, the apex court clearly held in the PCCI case, not all the functions of PCCIs are public in nature.
Yes, we know, realize that.
But therefore, in my case also, though RTI is applicable to me, like PCCI and others, all my functions are not public in nature. And regard to this, my lord, the affiliation process is purely a bilateral in nature. Okay. So that's my humble submission, my lord.
That's all?
My lord. Only to wrap up, my lord, my learned friend has read the content of the email, my lord, impugned letter, recognition letter issued by me to other sites, my lord. That the efficacy of the legality of that letters, whatever, Lordship will definitely address if Lordship overrule my contention that writ is maintainable. In that we will address it, my lord. So I don't need to go into that. Yes, my lord. Therefore, my humble submission is, my lord, the writ is not maintainable because the affiliation is not the public functions. Yeah. Number two, even if assume that it is functionable, though I'm not admitting, in view of the clear arbitration clause in the bylaws, my lord, he has to resort to that provisions, my lord. Here's a sufficient to interfere this, my lord. The action is an invitation, my lord, to come to the arena of the civil disputes, my lord, and to take over the autonomy of the arbitration authority, my lord, which is very, my lord, impermissible. Therefore, Lordship would reject that invitation, my lord, and dismiss the writ petition.
Mr.
We are given to understand that your Lordships is only deciding the maintainability as of
yes.
I'm not disposing the petition.
No, maintainability. No, if suppose we decide that it's not maintainable, we dispose of.
Yes, my lord. On merits. On merits.
On merits on a question of maintainability only.
Yes.
Because you have anything to say on the submissions of Mr. Paul regarding this, the only 2 points, public function and whether the disputes are arbitrable, that's all.
My lord, I will not touch those points, but there are certain submissions that has been made by Mr. Paul that my association has been defunct.
It's not defunct.
It's not defunct, my lord. My lord, because the timeline is very important.
The time again, it comes to the merits.
Merits, my lord.
See, whether you're defunct or functioning or not functioning, that is not the question right now what we are addressing. The only thing is that whether it will be maintainable at all, whether the IGU will be amenable to jurisdiction.
My lord, my lord.
That's all. Because the thing is that, and only in 2 points, whether the function is not, it's got a public function, and whether the disputes are arbitrable. That's all.
But in the event your lordships find that, my lord, assuming that the writ is maintainable, then your lordships will have to hear me. Then, my lord.
Of course. But you're not on those points. You're not submitting anything.
No.
So fine. You don't have anything to add to Mr. Changri's submissions.
No, I'm adopting.
Okay, fine.
Only one aspect, my lord.
Yes, Dr.
The submission was made, my lord, by respondent number 1 with regard to deep and pervasive control, my lord.
Yes.
My lord, there is a distinction, my lord, deep and pervasive.
Respondent number 1?
Mr. Sangreso made a submission. Oh, sorry, R2.
Yes.
Now, deep and pervasive control is one aspect of the matter, my lord. That is for the purpose of defining whether any authority is other authority within the meaning of Article 12 or not.
Just come again, sorry.
Well, deep and pervasive control, financial, administrative, or will be relevant only if any authority is to be brought within the definition of other authority under Article 12. So to say it becomes state, my lord. Now, what Supreme Court has said, my lord, even if an authority is not other authority within the meaning of Article 12, even then writ is maintainable against that authority. So, my lord, that is where there's a mixing up of the things, my lord. Conceptually, Article 12.
We're not doing Article 12 at all here.
My lord.
The only question is amenability and Article 12, two different things.
My lord.
Yes, we just talk about amenability.
My lord.
Jurisdiction.
My lord. But
What
that's
Mr. Paul is conversing is that the only thing is that, look, the action is, firstly, it's violative of Article 14 National Justice.
My lord.
He was not given any notice. Inquiry was held behind his back, de-affiliated. Now, after being de-affiliated, there's no unresolved dispute anymore because the arbitration clause won't address it. The arbitration won't address it because it's only if it's unresolved dispute. And since he's been disaffiliated, he's not an affiliated member anymore. So that bar that all affiliated members cannot go to court of law and apply to him. And since the dispute is over, so he has to come here. And coming here means that he's like challenging the arbitrary action of IGU and disaffiliating him.
My lord, on that I'll only have small submission to make, my lord. That these are writ proceedings, my lord. Now this is well settled, my lord. That any alternative remedy, whether be it civil suit or arbitration, my lord, there's no bar to writ jurisdiction.
Yes.
Alternative remedy by way of arbitration is not a bar, my lord.
Yes. What do you have to say?
But that's my submission, my lord. Even if we assume that there is an arbitration clause, my lord, subject to what Mr. Paul says, but the arbitration clause cannot be a bar to maintainability of writ petition.
No, that is a given. Yes. What else you have? I mean, are you supporting his case?
But it's not a question of supporting. I'm Union of India, my lord. I'm trying to distinguish between what Mr. Sangriso was trying to submit, that there is no deep and pervasive control, so writ petition is not maintainable. My stand is, my lord, that is not the correct picture. Even if it is deep, there is no deep and pervasive control. If it does not fall squarely within Article 12, my lord, but the IGU will be amenable to writ jurisdiction, my lord.
No, because of the different arguments, it's more what you call it, specific in the sense that the functions are discerned between public function and private function. Now that is what. So, from what I
affiliation, de-affiliation
from the submissions.
My lord, affiliation and de-affiliation in my humble submission, my lord, will fall the character of public functions, my lord. It can be private function, my lord.
But are they submitting something else? Are they said all of golfers in Shillong have to be called or something?
My lord, that is another aspect, my lord. Because the rules itself say, my lord, if we give an example, my lord, there is just, though may not be squarely applicable, my lord, there is a central government and there is a state government. There is a federal structure, my lord. It cannot be seen that there are 2-3 governments in Meghalaya, my lord, and the central government will recognize one of them. There can be only one government, my lord. Now the members, there will be election and they will be elected because of that, my lord. But today Mr. X is the chief minister, tomorrow Mr. Y is the chief minister. But there cannot be 2-3 governments, my lord. And that is a purpose.
No, but the ground situation is that there's this Mr. Nongbri's party, the Shillong Golfing Association. Then there's golf promoters. Then they said the other golf clubs also. And the thing is that there has to be only one body that is recognized or affiliated to cater to the entire golfers.
Well, in my humble submission, the entire scheme, the structure itself is not
just
correct.
Because suppose Mr. X not a member of the golf promoter society, doesn't mean he'll be debarred from competing or from But then it should not work that way. That you have member of SGA. So like if the tournament's held by golf promoters, they'll be out, or is that situation on the ground?
But my lord, if that is taken that way, my lord,
that's only
specific instructions on what is followed.
One thing, Mr. Paul, that's anxiety of course.
My lords, I have taken specific instructions.
Fighting within the state.
My lords, I have taken specific instructions on this query. Specific instructions on this query. I'll place it before lordships.
Yes, what happened to poor golfers?
My lords, it's like my lords, it's like this. If I may,
golf association.
My lords, if I may,
you all are fighting. I can't play golf.
No. My lords, it's like this. If I may. What happens is, well, as I submitted, ministry, national federation, state association, below that are the golf clubs. For the purposes of playing golf and paying green fees, well, they don't pay green fees to me, they don't pay anything to me. I cannot have anything to do with any of that. Somebody wants to play, doesn't want to play. I am only the body in the state, Melons, which recommends that these are the people from the state who can go and play in national tournaments. Insofar as, Melons, the pointed query that has fallen from
irrespective of which. Suppose you might have a grouse against Shillong Golfing Association.
Doesn't matter, my lords. It will depend on the ranking of the golfer. He's a good golfer, my lords. It's on ranking and handicap, my lords.
There's no discrimination.
I cannot.
Association
It's not on me.
On qualifications, there's a ranking, all India ranking, world ranking, according to that.
Whoever is, my lords, the best players from the state will be sent, irrespective of where they go and play golf.
The issue is as simple as we have the High Court Bar Association. But today, me and Dr. Muzika decide to form another association. Now, there has to be a body which has to decide which of the two should exist. So that is the issue.
No, you can't have that analogy. But in other states, they have their own small bar chains also.
But here, my lords, the law
in Calcutta itself, there came out displaced
in the
lawyers.
High Court, my lords, therefore.
Displaced lawyers bar association. I don't know what that means. When kicked out from all associations, they have their own bar association.
But when it comes to funding, to lawyers' welfare, one association has to be.
Well, it's now the law is settled also, insofar as any discipline of sport is
concerned. But that's the only worry also, because suppose whatever.
I cannot, my lords. I cannot, and I will say that with my lords, all humility, that I cannot distinguish on any player, irrespective whether he's playing for Shillong Golf Association, Shillong Golf Club.
Yes.
Golf Association also, my lords, will not have anything to do with it. It's Shillong Golf Club. Whether he plays for Shillong Golf Club, whether he plays for Assam Rifles, whether he plays for X, whether he plays for Y, whether he plays for Z. As long as, my lords, he's a good player, he will have, there would be the ranking, my lords.
Rankings maintained by whom? By the Shillong Golf Club?
No, my lords.
But state-wise.
State-wise.
I mean, who maintains in the golf club?
State-wise, my lords. It's state-wise and national-wise.
State-wise, national
and international. So, well, it's all on that. So, if somebody is a good golfer, my lords, is a good golfer. I can't just merely because, my lords, Shillong Golf Club is not with me doesn't mean that I.
Happen in karate federations.
Karate is different, my lords. Karate is a little more. It's a martial sport, so maybe things are a little different.
No, they've got good ranking. Also, you've got black belts. How many dancers? He's not allowed to.
Karate
federations controlling it.
That is not the that is not even the allegation here.
No, I'm just saying it's because it's just.
As a matter of fact, what is very interesting is the letter by which I am de-affiliated. If your lordship see the last two lines of that letter.
Yes, what does it say?
It clarifies the entire situation, my lords. If your lordship just see last two lines of that letter. What I have done till today, my lords, and what IGU thinks, it just clarifies the entire situation. Page 37.
Yes.
Paragraph 3, if my lords, can you have a look?
Yes.
We appreciate the efforts made by your association in the past towards promotion of golf and wish you the best in your future endeavors. So it's a fact, my lords, that we have promoted golf. We have got golf in Meghalaya to a certain standard where players from Meghalaya are representing.
How many years? Quite a number of years.
9 years.
So that's a given.
So if there was something, my lords, that I am actually, that allegation is not there against me, that there is no allegation of nepotism or otherwise. Your lordships have rightly said that whether I could do that or not. Even if I want, I can't do that.
His being affiliated for 4-5 years, does not take away my right to apply.
No. It's not that. It's the only thing he's agreed with is if the manner has been done. That's all.
Yes, Lord.
But my lord, the fact remains, my lord. It appears that Mr. Paul's association is consisting of Mr. Bajaj and whatever, XYZ, my lord. And here is Mr. Singhania and ABC, my lord.
So?
Now, are they true representative body in terms of the rules, my lord? The rules.
That's not the question.
The rules. My lord, that is relevant, my lord. How do we synchronize?
Well, it's like this. If I may, my friend was given.
So why is Dr. Mozika bringing that? Why? Who are these people? I mean, they are golfers, right?
They are all golfers.
My lord, what it says, the state. What I pointed out yesterday, my lord, the State Golfers Association Managing Committee or Governing Council has to be elected in a certain manner, my lord.
Yes, that has been done.
How can that be done?
Well, if it was not done, where was the question of IGU? Well, it's recognizing.
That's out of scope, this discussion. Now, if that is, then that we challenge.
Well, my friend was giving an example. If I may just take it forward from there.
Yes.
There's a central government, there's a state government.
Yes.
Now, well, it's 5 or 10 or 15 MLAs, what my learned friend is saying, cannot tomorrow suddenly say that I am also an equal state government. There cannot be 2 state governments in the same state. If, my lords, what my friend is saying that regarding elections and all that, you have to come inside that society, fight it out, maybe whoever wins. That's the case usually in other places, that both 2 factions come into one society, they fight amongst themselves. Here, that's not the case. Here, what they choose to do is, my lords, have another society and talk to IGU, get me disaffiliated, get themselves affiliated. That's the issue. I'll just come back to the legal issues, my lords, which my learned friend has raised very quickly. It'll just take me 2 minutes.
Otherwise, we'll finish. We'll close it.
Two arguments, my lords, which my friend Dr. Mr. Shangrizo has placed before Lordship, my lords. The first question, and he put a very pertinent question, which, my lords, I thought I should have placed before this honorable court. Now he says, whether does de-affiliation affect the public, my lords?
Yes.
That's the moot question to decide whether it's a public function or a private function.
Yes.
Now, as I have submitted before your lordships, my lords, I have, my members do not get to play anything. Merely because, my lords, I am the state association, I have no role insofar as games are concerned and things are concerned. I have no personal benefit in it. The state association. State association, my lords, discharges a public function of recognizing all the golf clubs in Meghalaya, finding out, my lords, which are the people who will actually be representing the state in the national games and the international games, recommending them to IGU. Therefore, my lords, if I am disaffiliated, IGU cannot function without a state association. The moot question is, my lords, IGU cannot function with a state association. They cannot sit in Delhi and then, my lords, get things done. They need a state association to give into effect their objectives. The moment that happens, my lords, it is a public function. It is not what my learned friend was trying to argue before your lordships, my lords, that it is under the bylaws, so therefore it is an internal arrangement between me and the state association. No. The central government mandates, and I pointed out before your lordships yesterday, you have to operate through the state associations. IGU sitting in Delhi cannot, my lords, decide that. My lords, the moment that comes, then, my lords, any relation between me and him becomes a public function. I am a public functionary, he is a public functionary.
No, but his question has some weight because he said whether the action of the affiliation,
which is why I say,
is a public.
It affects the public, my lords. That's what I'm trying to say. If I do not exist,
recognize not the body in this place.
Exactly the point, my lords. They have to have a state association. So the moment they have to have a state association, my lords, appointing or de-appointing a state association becomes a public function. It's not a private function that if I wish, I can operate through you or I can operate directly. You have to operate through me. That's the mandate of law. So the moment that comes into play, my lords, my relation vis-a-vis IGU becomes a public function.
So affiliation is a public function.
Absolutely, my lords. Absolutely.
Okay.
Well, it's what I will take your lordships to this compendium which I had placed before lordships yesterday. Now, at 3 point, this is, my lords, the National Sports Development Code of India 2011.
Yes.
At 3.10, my lords, I'll just read. It says, at the national level, there will be only one recognized federation for each discipline of sport. Only the duly recognized National Sports Federation will be entitled to financial grants as admissible. Only one state union territory association from each state shall be admitted as member of the federation, provided it has a minimum of 50% of the district level associations affiliated to it.
Where are you reading from?
Well, this
30th
is
March.
My lords, this is the
30th March 2010.
Yes, this is that one. So it says, my lords, any organization of an Indian standing and connected with the sport may be given the status of that of a state or that of a union territory and admitted and affiliated as a member. Other categories of membership may also be given, but while each affiliated state union territory shall have a right to cast a vote in the general meetings, while granting recognition affiliation of a state
Where are you
union.
reading from?
Well, this is this. Unfortunately, my lords, we could not.
It's not before.
We'll just make a compendium, and my lords, I'll give it. I pointed out. This is the sports policy of the government of India. They say, my lords, while granting recognition affiliation to a state union association.
Answer that he said it's a policy decision. It is not statutory.
Well, it need not be statutory. Need not be statutory. The first argument, my lords, which we can be culled out from the entire thing, which I think my friend Dr. Mosika was also saying, the two aspects. If it is statutory, my lords, you come under state. But what the law has now come to being is that you may not be a statutory body, you may be a private body, but you are entrusted to perform certain public functions which affect the public at large or a section of the public. And the section of the public or the public at large must accept that decision of yours as the final authority on the subject. The moment that happens, my lords, that's a public function. So what is sought to be argued, my lords, I may not be state. Very well, you are not state. BCCI, the last paragraph, there's a first part, you are not state, but you are still amenable to writ jurisdiction because of the simple reason that you are discharging public functions. And this part is very important, it says, while granting recognition affiliation to state union associations, the national federation.
Photocopy that.
We'll make a copy of this entire thing and give it. Take into consideration the representative character of the state union territory, so as to ensure that only true representative body of the game gets recognition affiliation. Yes. The other argument is what has been placed. There's this judgment of the Chennai High Court which has been placed before Lordships insofar as
arbitration
clause is concerned. This judgment, my lords, in my humble submission, would have no bearing, primarily because it's a suit. It's a civil suit. And there, my lords, the Lordships have taken a view that once there's an arbitration clause under Section 8 of the Arbitration Act, my lords, it is obligatory on the part of the court to send the parties for arbitration. Insofar as we are before a writ court, the hands of a writ court are not tied down merely because, my lords, there is some clause. Now, in this extent, my lords, there's a judgment of this honorable court. My lords had the occasion to deal with this, my lords. This is Sumarlin Wankar versus Secretary KHDC, decided on 10/10/2019, where my lords had to deal with the issue of alternative remedy. And my lords, this court itself, my lords. And my lords have placed reliance on the decision of the Honorable Supreme Court, my lords. If I may take your lordships to paragraph 18, at page 9. Because that's the settled law, my lords.
Yeah.
The existence of an alternative remedy otherwise also is not an absolute bar to entertain a petition under Article 226 of the Constitution of India. As per the law laid down by the Honorable Supreme Court in the case of Hanbanslal Sahania versus Indian Oil Corporation, it has been held that a rule of exclusion of writ jurisdiction by availability of an alternative remedy is a rule of discretion and not one of compulsion. The judgment at para 7, my lords have extracted para 7. May I just read para 7? So far as the view taken by the High Court that the remedy by way of recourse to arbitration clause was available to the appellants and therefore the writ petition filed by the appellants was liable to be dismissed is concerned, suffice it to observe that the rule of exclusion of writ jurisdiction by availability of an alternative remedy is a rule of discretion and not one of compulsion. In the appropriate case, in spite of the availability of alternative remedy, the High Court may still exercise its jurisdiction in at least 3 contingencies: where the writ petition seeks to enforcement of any fundamental rights; 2, where there is failure of the principles of natural justice; or where the orders of proceedings are wholly without jurisdiction. Admittedly, my lords, here there is a case where the principles of natural justice have not been followed by the IGU. Because more than anything, my lords are also sitting in writ jurisdiction, which is a court of equity. Your lordships would balance the equities to see whether any wrong has been done or not. And what I had submitted before your lordships, my lords, the higher in the hierarchy you are, the more it is expected of you to act fairly.
Yes, you just, a compendium, you just supply the, you want to give bullet points or?
Bullet points. Well, as my friend has taken out a judgment, we'll place it which says that these guidelines, which I was referring to, the NSDCI, what my friend was saying is policy.
They've been referred to any judgment?
Yes, yes. It says, well, as they are binding.
In which judgment is this?
Well, this is Narendra Batra versus Union of India.
It refers to the BCCI.
I could. If your lordships kindly have a look at, this is ILR, paragraph 286.
Our judgment is so long.
Well, it says that, well, this is that Netaji cricket, this is that earlier BCCI, page 404, if my lords kindly have. 404. Netaji cricket, my lords, that's the first BCCI case, which says, my lords, para 285, if my lords have it, I'll just read it.
Yes.
It has been held here in 284, I'll read, my lords. With regard to the popular sport like cricket, the apex court has needed to say in para 85 of BCCI versus Netaji cricket that events leading to these appeals rises an abysmal picture and a solid state of affairs. It has been held here and above that these guidelines are valid and binding. The judicial precedents noted here and above have stated that the breach of even non-statutory guidelines which have been framed for the purpose of regulation of dispensation of largesse results in actions being voided. Well, they refer to these international
guidelines. Where are the guidelines? Where is specifically that these are the guidelines?
286. Well, if your lordships kindly have a look. The government stand before this court in the affidavit dated 16th May 2025.
What is guidelines 2010? The judgments of?
Well, this is 2009.
Hmm.
Well, it says the government, because 2010, my lords, they are compiled into the compendium. These guidelines start way back from the 80s. Time to time, the instructions which have been issued, it says, my lords, that the government stand before this court, and the affidavit dated 16 May 2005 indicates, itself states that the government is required to do, if it is guidelines have been breached, the deposition on behalf of the government on this aspect reads thus, that the only action that the government of India can take against these defaulting national sports federations under the prevailing circumstances is to stop giving financial assistance it is providing to them as per the policy guidelines. But the government in general refrains from taking such harsh action as it would adversely affect the interests of the Indian sports persons having a lot of potential to excel in their respective sport. My lords, and more importantly, their memorandum itself says, my lords, that it is binding. If my lords, can you have a look at page 73, clause 56.
Page or writ petition?
Writ petition, my lords, page 73. It says that it is binding. $56 million.
Yes.
Ministry of Youth Affairs and Sports, Government of India, the Indian Golf Union shall abide by all the guidelines of the Department of Youth Affairs and Sports as issued from time to time. This is part of their rules and regulations.
Okay, then.
So if it is undisputed, nothing survives.
We just getting concluded. Parties can submit the bullet points by.
Rizzo has come up with a hair-splitting argument.
Yes, precise and short.
And
unlike his usual style.
I was actually congratulating him on this, fellas. I said it puts us in a
back foot.
Obliged.
Just 5 minutes. Let's come back. That matter, Dr. Todi will take it up now. Yeah.
Item number 5.
Yes.
My lord, before my learned friend, my lord, he continues, my lord, if lordship permits me, my lord, can I add something, my lord?
Yes, of course.
Only one aspect, my lord, remained, my lord, yesterday, my lord.
Yeah.
But what I was submitting, lordship, my lord, that only two options were left with them, my lord. In
Only
fact,
will come back to that letter, Dr. Yes, you submit the use. We come at a letter 20th March 24, where you say that this is
yes, my lord.
Now before that, you
my lord, they had to re-verify. Only, my lord, that aspect was there. My lord, earlier also, what happened, my lord? So far, the May 2019, my lord, that earlier also required, my lord, them to re-verify if they choose, my lord. That was the, my lord, direction. In fact, my lord, what happened? These were all the payments were centrally audited. Central department, central government, my lord, they audited it, and my lord, all the records are with them. So, my lord, while passing the my lord, order, the Honorable High Court held that, my lord, this is case payment is to be made accepted because this subject matter was related to prior to March. This was September 2009. It was September 2009 was the notification that from September 2009. Because then, my lord, all payments had to be made by check. Otherwise, it was not admissible because they brought the checklist. But so far, the claim of the petitioner was up to 31st March 2009. That means 1st October 2008 to 31st March. So, my lord, this honorable court held that, my lord, prior to notification, my lord, the case payment, even if it is there, my lord, it is to be honored. It cannot be operated retrospectively. And, my lord, that one, my lord, handle given to them, if they choose, my lord, so far they choose that they can again re-verify, although so far the genuineness of the transactions were audited by the central audit team. So, my lord, again, my lord, they were given the liberty, but they didn't opt it. My lord, even 2019's case, my lord, even, my lord, for 5 years, my lord, they didn't re-verify. Then, my lord, second round, when, my lord, it came before the, my lord, before the division bench, my lord, then, my lord, again, my lord, division bench said that yes, because earlier order was misread, your handle was given to you to re-verify, but you were not re-verified. So, case payment you have made, honor it. If you want, you again re-verify. So, my lord, ball was in their court to re-verify because there is nothing wrong in re-verifying it, but they should be doubly sure so that public money is, my lord, so that somebody may not take. But the intention was that, but in spite of the fact, my lord, so far the 24th order, my lord, which lordship just referred, my lord, March 2024, they said, my lord, at the last para, if lordship can come to last para, page 58, what they say, hence, after detailed deliberation, the department decided that the application of Meghalaya feed products for grant of rejected claims under the transport subsidy scheme cannot be accepted as only payment being reflected in bank statement will be taken into account for transport subsidy scheme claims. That means, my lord, it has to be check payment. Only check payment, my lord, that can be reflected in the bank account. Cash payment to, my lord, cannot be reflected in bank transaction. As such, no relaxation is to be granted in the 44 points checklist, even though the checklist has been imposed with retrospective effect. Then, now, therefore, the matter of rejection of claims of Meghalaya Feeds products has been examined in accordance with the directions of the Honorable High Court of Meghalaya and is hereby rejected as not permissible. So, my lord, in fact, my lord, not in accordance, my lord, though they said it in accordance with the High Court direction, my lord, they have examined it. My lord, in my response submission, my lord, they have not examined. So, meaning thereby, my lord, they are again sitting over the matter that, my lord, case payment, my lord, you can re-verify it, my lord, they should re-verify it, my lord. Still, my lord, body is in their court. They cannot close it abruptly, my lord. If they close it now, without re-verifying, my lord, then two options are available, my lord. Option one, as per the earlier central audit team, whatever they verified it, you honor it since the case payment was permissible as per direction of the Honorable Court, my lord. Subsequently, my division bench also said that you have completely misread, and in fact, it is acted contrary thereto. But they have acted contrary to the earlier order. So, my lord, the options are with them, my lord. So, my lord, they cannot say again and again the same thing
that my cash transaction is not allowed. So this per se, my lord, it's not as per the direction of the Honorable Court, my lord. This is the only, my lord, I want to highlight. My lord. So, my lord, they can re-verify. And then, my lord, while re-verifying what is there, my lord, re-verification, my lord.
Yes.
In my respect to submission, my lord, suppose, my lord, they want to re-verify. They can say, so this transaction, these transactions, you bring detailed records. What is the track number? What is this? Of course, my lord, after 15 years, I think 2009 period, 8-9, almost, my lord, 15 years, my lord, 16 years.
16 years.
So 16 years, after 16 years, my lord, the trackers, my lord, whether the tracks are still playing, but it is very difficult, my lord. Still, my lord, efforts can be made. Nothing wrong in it, my lord. Suppose they said.
They have not done that. They just referred back to their old.
2019, my lord, they should have verified. Even then, 6 years gone by. So, my lord, even then you have not chosen to re-verify it. Meaning thereby, my lord, whatever the central audit team accepted it. Because the main, my lord, their difficulty was that cash payment transaction is not to be honored. Which, my lord, High Court said, my lord, no transaction payments prior to September.
2009.
Yes, my lord, it can be accepted. My lord, it can be paid. So, my lord, now, still, my lord, we can try. Still, you can suppose they said that no, you bring these vehicle details, whether these vehicles were in service at that relevant point of time, whether these are fictitious number we have just given. This can be done, efforts can be done. But again, Manot was a very strange case, Manot, of course, at this stage. Any excess can be done or not, Manot. So, Manot, my response submission that Manot, how can they sit over this? Manot, this is something Manot, very strange, Manot. What they should not, Manot, and responsible person. An IS officer, my lord, they write like this, my lord, that, my lord, they examined it and, my lord, it's not permissible. Again, they retrospectively, my lord, the checklist is in operation. When they said it prospective, my lord, how can it be retrospective again and again, my lord, can be said? So, this is my respect. Submission, let my friend submit, my lord, what I want to say.
Lord, I have made a compilation of the relevant documents, my lord. These are called out from our affidavit and their petition, my lord, just for convenience, my lord. But the story starts from page number 1, my lord. This is the first order passed in 2019 by Chief Justice Mir, my lord.
Yes.
My lord, the direction is at page 4, para 7, my lord. It says, my lord, the petition is disposed of with the direction to the respondent that they shall reconsider the claim of the petitioner in the light of the aforesaid observation for disbursement of the subsidy amounting to rupees so and so, respectively, along with interest on the date pre-audit report, and to pass appropriate orders therein, whatever permissible under rules within a period of 4 weeks. So, direction was to reconsider, my lord. Pursuant to this, page 5, my lord, this was the order passed by the department, 2nd August 2019, my lord.
This order was dated 3rd of 3/5. Okay.
3/5/19 and compliance is 2nd August 2019, my lord. So we accepted some claim, my lord, partially, 1,98,00,000 rupees, and it was paid to them, my lord. In the meantime, union filed an appeal against the order of the single judge, my lord. That is at page 7, my lord.
Yes.
I'll just read this order, one page order, my lord. This is 24th.
This order was passed in, okay, yes.
So,
It's
1922
only.
my lord. Though we filed appeal in 2019, my lord, but somehow it came to be listed or heard only in 22, my lord. It says, my lord, the appeal is directed against an order passed by a single bench of this court on May 3, 2019. It is fairly submitted on behalf of the appellant union that though the present appeal has been carried, the impugned order has been substantially complied with. Learned Assistant Solicitor General submits that a fresh writ petition has been filed by the first respondent, SSC, upon not being satisfied with the extent of compliance with the relevant order by the department. Since it is accepted position that the order impugned has been given effect to by the appellant herein, the present appeal can no longer be maintained, though the legal issues involved is left open for consideration in the appropriate matter. This is how the writ appeal came to be disposed of, my lord, by leaving the questions, legal questions open, my lord. Now, my lord, as observed in this order, my lord, the two writ petitions, my lord, they are not happy with the compliance, my lord. They filed writ petitions, my lord. Two writ petitions,
amounts which they feel.
my lord. Two writ petitions because of the relevant different financial years, my lord, but the substance was same, my lord. Now, this came to be disposed of by lordship. I'll take your lordship to page 22, my lord. I referred on the yesterday also, my lord. From page 21, my lord, para 13.
Yes.
In the opinion of this court, in this scenario, therefore, the burden of substantiating the claim made on the basis of cash transactions would squarely lie upon the writ petitioner, subject to verification thereof of the claim by the respondent. The respondent, therefore, on not being satisfied to the clearance of the state level committee of the claim as well as the pre-audit report, on being permitted by this court, had by the re-verification exercise reconsider and allow payment by the impugned order to the extent they deemed admissible. This court in these circumstances, therefore, while sitting in writ jurisdiction, cannot and is not in a position to render any conclusive finding on the claim of the petitioner, as surely this will fall within the realm of disputed facts which has to be proven. The question, therefore, of determining the legitimate dues of the petitioner by this court, or to endorse the claims as made and to direct as for payment as claimed for which is mandamus is sought at this stage, is well nigh possible. In view of the matter, therefore, these writ petitions are closed and disposed of, leaving the writ petitioner to take a recourse to appropriate civil proceeding for the relief claimed if so advised. Against this, they filed an appeal, my lord. Page 23 is the order 13-10-23. Now, my lord, I read certain portions of this order. The the Honorable Division Bench by and large agreed with the findings of your lordship, my lord, but still giving some, showing some leniency, my lord. It only said, my lord, para 12, I'll just read, my lord.
Yes.
In appeal, there is very little that can be done at this stage, since evidence cannot be received for this court to be satisfied that the entirety of the claims made for two periods was actually disbursed for the appellant to be entitled to such amount. However, such exercise can be conducted by the union. In fact, the previous order of this court of May 3, 2019 obliged the union to conduct such exercise, which the union failed to undertake. Accordingly, the appeals are disposed of and the orders impugned are modified by directing the respondent to re-verify the rejected parts of the claim for the 2 weeks period by calling for documents and other evidence from the appellant. Calling for documents from them, my lord. A rational and meaningful verification should be conducted by the union, and entire exercise completed within 8 weeks from the date. In the event any part of the claim is to be declined, cogent reasons for such rejection should be furnished. Needless to say that the interest awarded in terms of so and so, we can skip this part, my lord. Para 14 is slightly important, my lord. In the event that any part of the balance claim is disallowed, it will be open to the appellant to institute an appropriate action before a civil forum for such part of the claim. After this order, my lord, page 30, lordship kindly sees, my lord. On 19th February, we issued a letter to them, my lord.
Yes.
Sir, I am directed to refer to the Honorable High Court of Meghalaya order dated so and so. We will skip, my lord. Para 2, I would like to inform that the in-person meeting chaired by Sri Balamurugan D, Joint Secretary, DPIIT, has been rescheduled as per your request. Consequently, the meeting will now take place on 22/2/24 at 11 a.m. in Vanijya Bhavan, New Delhi. You are therefore requested to make it convenient to attend the proposed meeting along with the detailed documents in order to access the eligibility of the claim of the above mentioned unit. Kindly acknowledge the same. Now, next page, my lord. This is 26th of February 24.
But they have not come in affidavit, have they? These documents?
They are in affidavit, my lord. These documents are on my affidavit, my lord. Now, yes. Next page, page 31, my lord. This is 26th February 24. Meeting scheduled on 22 so and so so and so. Sir, I am directed to inform that in-person meeting under the chairmanship of Sri Balamurugan so and so took place on 22/2/24 at 11 a.m. in Vanijya Bhavan, which was attended by your representative so and so so and so. Since your representative failed to produce documents and other evidence to re-verify the rejected parts of the claim during the specified period as per the Honorable High Court of Meghalaya order dated 13/10/23, and on the above mentioned subject, when the Honorable Court has issued the following directions so and so. Next parameter, you are therefore given the last opportunity to submit your submission along with the required documents and supporting evidence by February 29 to re-verify the rejected parts of the claim of the 2 periods. Now, in response to this, my lord, there is 32 is a letter from them, my lord, to Under Secretary so and so. Married, my lord.
Yes.
We have received your mail dated 26/2/24, forwarding therewith scanned copy of letter number so and so dated 26/2/24, giving reference of the meeting dated 22/2/24 attended by our authorized representative. We have noted with shock and surprise the contents leveling the allegations against us using the word since your representatives failed to produce documents and other evidence to re-verify the rejected parts of the claims during the specified period as per the Honorable High Court of Meghalaya order so and so on the above mentioned subject, wherein the Honorable Court has issued the following directions. I may skip this, my lord. Next para, you are therefore given the last opportunity to submit your submission along with the required documents and supporting evidence by February 29-24 to re-verify the rejected part of the claim. From the contents of your letter, it is crystal clear that you have willfully and deliberately violated the order dated so and so. So, my lord, I may not, what they do, my lord, is instead of supplying the document, my lord, a verifiable documents to substantiate their claim, my lord. Because your lordship will see, they are saying that they made cash payment to the truck drivers, my lord. We don't have, because if there was a bank transaction, my lord, those are, which has evidentiary value, my lord. Here they don't produce any document, my lord. They simply give a statement that we have paid so much money by way of cash payment to truck drivers, my lord. And on the basis of that, they are claiming the subsidy, my lord. And these cash receipts from truck drivers are unverifiable documents, my lord. So that is what we said, that you please bring some evidence at least to prove your case that you have actually incurred so much of expenses in cash on truck drivers, which they don't produce, my lord, and they issue this kind of letter. Now, after this, my lord, the department has passed the final order, which is before the challenge. Now, in my humble submission, my lord, lordship has seen the direction was to reconsider, my lord, the claim. They were directed to supply the material.
On them. They did not come forward with the required materials.
And moreover,
so it's impossible for you to decide.
My lord, and moreover, my lord, the division bench also, if any claims are rejected, they are at liberty to file civil suit. So, my lord, in my humble submission, there is no willful, no disobedience, my lord, firstly, and there's moreover, there is no question of any willful disobedience of any order, my lord. They are at liberty, my lord, in terms of the orders of the division bench to file a civil suit, my lord.
Okay, anything else?
What landed prince stated, perhaps it is not correct in in details. Let me, my lord. So little, my lord, the earlier order which my learned friend has referred, and that page 37 of the contempt petition, my lord, because that earlier single bench judgment, my lord, the Honorable Chief Justice order, just said no liberty was granted, my lord. That is not correct position, my lord. Lordship may kindly come to paragraph 6.
Yes.
May I read, my lord? The object of avoiding misuse of the subsidy is achieved because the claim of the petitioner has been audited by the Pay and Accounts Officer, Pay and Accounts Office, Ministry of MSMF. Therefore, there could be no reason for the respondents to deny the claim of the petitioner. That apart, it shall be open to the respondents if they so choose to re-verify. My lord, learned friend said that no liberty was granted. It is there, my lord. If they so choose to re-verify the case, they have any doubt about the audit conducted by the Pay and Accounts Officer, Pay and Accounts Office, Ministry of Emphasis. Otherwise, the amount shall be disbursed subject to adherence to the norms. Then, my lordship will kindly see how they have acted thereafter, my lord. Therefore, the division bench judgment, my lord, was reiterated the same thing. The liberty earlier was granted, which lordship may kindly come to. I think, my lord, my land firm has missed few lines, my lord.
This order is 2012-23.
No, my lord. This earlier, what is the May 2019, my lord.
Division bench.
Single bench, my lord. In fact, my lord, then, my lord, this was reiterated by the division bench. That, my lord, earlier also.
All merged, Mr. Dr. Turi.
Exactly, my lord. I am obliged, my lord. So, my lord, once merged, then, my lord, liberty was granted them to re-verify. Now, re-verify means what, my lord, what I have submitted. Re-verify, if you lordship will kindly, now, my lord, this has to be read in conjunction with the earlier order, because division bench also referred the learned single bench judgment, my lord. So, this has to what the learned single bench has stated, but it merges with that, my lord, and my lord, it is reiterated again and again, that May 2019 order. Now, division bench again, my lord, said, my lord, that which, my lord, my learned friend has just read, my lord, some 1-2 line, my lord, is very important line, my lord, is missed. But page 32 of the, my lord, contempt petition, in appeal, there is very little that can be done at this stage, since evidence cannot be received from for this court to be satisfied that the entirety of the claims made in the two periods were actually disbursed for the appellant to be entitled to such amount. That's what, my lord, what I just stated, my lord. However, such exercise can be conducted by the union. In fact, the previous order of this court of May 3, 2019 obliged the union to conduct such exercise, which the union failed to undertake. My lord, they deliberately, my lord, did not exercise the direction, my lord, which honorable court must have directed. It has been reiterated by the division bench, my lord. And my lord, for 4 years, from 19 to 2023, my lord, they were just sitting over the matter. Though, although, my lord, liberty was, if they so choose, that means because they thought that it's correct. My lord, they thought my lord, if my lordship permits me, my lord, to add something, my lord. In fact, my lord, they also know.
But then the para 13, it qualifies the observations made in para 12. Impugn or modified. The orders impugn or modified by directives upon to re-verify the rejected parts of the claims of 2 periods by calling for documents and out from the appellant.
Yes, no doubt about it.
The burden shifted on you.
No,
so verification, their proper verification, re-verification rather, will be consequent upon the material supplied by you. That's what is submitted.
My lord,
so that's the only thing. So only one thing. What we're looking at is very limited.
Yes,
scope in context. Whether this order has been willfully violated and whether it is also impossible to comply with. That's the only thing. That compliance of the order has been, frustrated for other factors, other accounts.
My lord, in my respect to submission, my lord, perhaps, my lord, if your lordship permits me, my lord, respect submission is like this, my lord. In fact, what happened, my lord? Normally, my lord, in fact, my lord, for 4 years, my lord, when they were sitting over the matter, because they also know central team has already, my lord, audited it. So very little scope was there, but still if they so choose, court had observed and they used the words, if they so choose. They did not like it, so to re-verify it. Now again, my lord, when it reiterated, now when re-verify, my lord, re-verify, lordship is also aware. Re-verify means what, my lord? While the documents are with you. Re-verification means what? Re-verification means, my lord, you will ask what you want, details what you want. Then, my lord, that is for re-verification. Re-verification, my lord, once it is re-verified, my lord, again that is the narrow meaning cannot be given to the word re-verify. Now, if this is reconsider, my lord, if suppose a reconsider word is again reconsider a word which can be, that means you may consider again, you may not consider again. That is the afresh the matter starts. But when it is re-verify, my lord, the matter does not start afresh. Afresh means you can again look into the matter which already central team has already been audited. Only, my lord, again at that relevant point of time, you have rejected because it was cash payment. Now, my lord, lordship may kindly come to next para, my lord, which is very, very important para, my lord. Then, my lord, I will also refer 2-3 letters, my lord. What is their mindset? Lordship has wanted me to read para 13. Accordingly, the appeals are disposed of and orders impugned are modified by directing the respondent to re-verify again. But the word is refer the rejected parts of the claims for the 2 periods by calling for documents and other evidence from the appellant. Yes. That means you will call for the other documents which you want. Now, my lord, I am coming to that. What they wanted, my lord. A rational and meaningful verification should be conducted by the union and the entire exercise completed within 8 weeks from the date. In the event any part of the claims is declined, cogent reasons for such rejection should be furnished. Cogent reasons, what cogent reasons they have furnished? Again, my lord, the reasons furnished is that it operates retrospectively. Case payment operates retrospectively because the case payment, our notification operates retrospectively. That is the cogent reason they have given, and based on that is the cogent reason. Because of that, my lord, you cannot be, your claim cannot be entertained. But still they could have verified. Now, my lordship kindly can see, my lord. Detailed documents means we have only detailed, but we stated to them, you tell me what documents you want. Detailed documents. Detailed means they have to detail it. Lordship may kindly come. First letter, page 44. Letter the 5th February 2024, which, my lord, my learned friend has not read. 5th February 2024. Kindly see, my lord. My lord, it is in compass, my lord. May I read, my lord? This is very important, my lord. This is very important, my lord. This will justify, my lord, what they want to say. I am directed to refer to the Honorable High Court of Meghalaya's order dated 13/10/2023 on the above mentioned subject, wherein the Honorable High Court has issued the following directions. That direction was there, my lord. Accordingly, the appeals are disposed of and orders impugned are modified by directing the respondent to re-verify the rejected parts of the claims for the 2 periods by calling for documents and other evidence from the appellant. A rational and meaningful verification should be conducted by the union, and the external exercises can be completed within 8 weeks from date. In the event any part of the claims is to be declined, cogent reasons for such rejections should be furnished. Needless to say that interest awarded in terms of the Supreme Court order as indicated in order dated 2nd August 2019 will apply if part of the balance claim is allowed. Therefore, this is very important. Therefore, in due compliance of the Honorable Court order, a virtual meeting under the chairmanship of so and so for Department Industry scheduled at 12. My lord, virtual meeting, my lord, they re-verify. My lordship will kindly see how, my lord, how they have dealt with the my lord, Honorable High Court order. So by calling virtual meeting, my lord, they want to verify. So meaning that they want to just, my lord, I was just how to, my lord, just to hush up the matter, and that too also, my lord, after taking extension, my lord, after 6 years, by virtual meeting, my lord, they will re-verify. Then lordship will kindly see next letter, date 19 February, lordship may kindly come straight to para 3. You are therefore requested to make it convenient to attend the proposed meeting along with the detailed documents. Detailed. Which detailed documents? That means you have to detail.
Okay.
But you have to detail it, but you can verify again and again. There is no doubt because in compliance to detailed documents, which are detailed documents, let them show these are detailed. Then we said that you let us know.
Okay, yes.
Then, my lord, you see, along with the required documents. Again, my lord, they said next letter also. You are therefore given the last opportunity to submit your submissions along with the required documents. Required documents, that means you will require. They will say they give the vehicle number and the vehicle registration number. Again, you may say, so that again you can, from your own source, you can depute some person to verify whether these tracks are in fact actually exist or not. That is the meaningful, because that what the court said is meaningful verification has to be there. And the cogent reason has to be given. Then, my lord, lordship may kindly come straight away to them. Again, what they say, last, my lord, the last para I read, my lord. Before that, my lord, lordship may kindly come to page 57 of their last with impugned order. May I read, my lord? This is very important, page 57. Also, that the checklist of transport subsidy provides for payment of transporters only by check. These are the cogent reasons they have given for denial, my lord. Cogent reasons. What as per the in compliance with Honorable High Court direction, my lord. Transporters only by check, that payments made in case are ineligible for encashment. Date 5 notification number so and so, dated 20th November. That was the date from which, my lord, the check payment was required. The Department of Industry Promotion has issued a checklist A for scrutiny of claims under transport subsidy scheme, wherein as per para 2, it is categorically mentioned as all claims arising from transportation of raw materials and finished goods prior to 10/9/2009 will be examined.
One thing, Dr. Turi, that time when they called you when doing verification, did you supply any materials or nothing was? You asked them to verify by themselves.
My lord,
that's the only thing.
We told them, my lord, you let us know what you want.
Hands to clap.
But in writing it is there. Let us know what you want. That means, my lord, if documents are with them. So, my lord, now, my lord, two things are there. My lord, about 4,000 documents are there. There were 4,000 vouchers. It is period of 6 months. 6 months period, my lord. Around 4,000, my lord. That was 4,000 trucks payments were made. So, my lord, now, they may say either randomly or elaborately, let them verify, but they should ask us what you want. They said the detailed documents. Detailed documents, they have incovered it. My mindset, they know it. What High Court said, the detailed calling documents. Calling documents means all the documents are with you. These documents are with them, audited parts are because whatever central government, what they do, but they don't return it. After audit, they keep the records with them for safe custody, for their future reference, my lord. They always keep it. So, my lord, with that, my lord, they can re-verify and calling documents, detailed documents. Then, my lord, they can say that these documents they will supply to the extent possible, my lord. But now,
we'll pass orders.
Much obeyed, much.
Item number 6. Item number 6.
submit it is. Your instructions?
My lord, I'm praying if this matter will be taken up next week, my lord.
We'll close it.
My lord.
You're just unnecessarily prolonging the...
Nothing left in the matter, actually. Right? Nothing left in the matter.
Nothing left. I think we'll close it, Mr. Paul.
The issue is that they are saying, well, that the supply has been made, but...
You know L1 also?
Well, I'll just seek some instructions on this matter.
You have taken time repeatedly, Mr. Paul.
Well,
you just see the order sheet has become...
Well, that's my habit on Monday.
But nothing remains. But otherwise, also there no relief can be granted.
No, because Malaj, I'll have to make a prayer to mold my relief before your lordship.
They can have
my lord, which is what
mold will grow on relief.
Well, that's my habit on Monday. Because even if it is supplied, as my friend has rightly pointed out, then I can go in for a civil suit.
Yes, I mean.
But to that extent, I'll just
have liberty now itself.
Liberty now. Yes.
Well, heaven will not fall in a day's time.
Nothing more can be is possible in
material
this proceedings.
My lords, I kindly have it on Monday.
Monday, okay.
My lord, in that case, Wednesday, my lord. Monday, Tuesday, I'll have to.
Even a day also doesn't matter.
He's done his job.
That you heard the view of the court. We're going to close it.
Well, I would have to find some way out. Insofar as seeking a relief is concerned.
My tenacity, but I mean some cases are beyond redemption.
Lady list 21.
Obliged. Yes. Look for a state. Yes. Which one? This one.
My lord, in the morning we sought lordship accommodation in the morning.
Where's Mr. Sen?
My lord, he is not seen now. My lord, so your lordship, give me a little time. Yes. Give me a option.
26.
Yes,
I'm praying for 2 weeks' time, lordship.
Why?
Mr. Chanda is not available today. Mr. Chanda is not available today.
Not well.
No, lordship. He has some other matters, lordship.
What is this?
It's regarding remonstration.
Remonstration? Which trade?
This is GD trade. Lordship, there's an order passed by your lordship. It can come after 2 weeks, lordship. I'm handicapped.
It's covered case.
Lordship, your lordship has passed one order, but your lordship has made an observation that will not be a precedent, lordship. But we want to place that judgment, lordship. It can come after 2 weeks.
Live up to the prayer of the counsel with the petitioners.
27.
Well, it's that affidavit bringing on record the notification, Melons, of the Administrative Affairs Department. We are in the process of doing it. Melons, I kindly have it next week.
Yes, Mr. K. for counsel prays for the next time to furnish the notification issued by personal.
Personal and AR department.
Yes.
Apply.
Well, it's connected matters till item 31.
32.
This matter pertains to the pay and salary of the officers and staff of the High Court, Milord. What has happened in this matter is pursuant to the creation of the High Court of Meghalaya, Milord, certain staff, Milord, who were working under the Guwahati High Court, Milord, then became part of the High Court of Meghalaya, Milord. Milord, in the year 2013, at page 46, annexure 2, page 46, annexure 2, Milord. service rules were notified, which were called the High Court of Meghalaya Recruitment and Conditions of Service of Officers and Staff Rules 2013. Under the 2013 rules, at Rule 10, which is at page 49, it provided that all High Court employees shall draw the pay scale, allowances and other benefits as approved by the state government. So under the 2013 rules, it was the state government which was the approving authority. Now because of the anomaly in the pay of the officers and staff of the High Court, a representation was made to the Honorable Chief Justice, which is at page 73, Annexure 3. This was dated 1st of June 2016.
Yes.
So there was an internal committee of the officers and staff, and upon examining the pay structure, this representation was made with certain recommendations. This was addressed to the Registrar General. Pursuant to this, pursuant to the representation, your Lordships will find at page 86, Annexure 4. This is a proposal, by the Chief Justice, through the registry. This is dated 13th of July 2017, This proposal was forwarded, to the Secretary of Law Department, If I may read, it reads, in inviting a reference to the subject cited above, I am directed to state that the officers and staff of High Court of Meghalaya have filed representation before the registry on various anomalies that have crept up in the pay and allowances since the establishment of the High Court of Meghalaya. The representation was duly placed before the single judge committee constituted by the High Court of Meghalaya, and thereafter the same was placed before the Honorable Chief Justice for consideration. During its consideration, it was found that the officers and staff of the High Court of Meghalaya have been drawing pay under two different state pay rules, that is the Assam pay rules and the Meghalaya pay rules. Hence, it was decided that after the establishment of the High Court of Meghalaya, the continuation of Assam pay rules is illegal and impractical, and all employees are to come over and opt for the Meghalaya pay scale under the Meghalaya Service Revision of Pay Rules 2009. The employees expressed their satisfaction on coming over to the Meghalaya pay, as they would be getting less pay than that they are drawing in the Assam pay, for reasons that the employees who were working for more than 10 years and above are drawing Assam pay scale. When brought into the present Meghalaya pay scale, would be drawing lower net pay than what they would be drawing in the Assam pay scale if continued. The allowances and other benefits in the Assam pay are much higher than that provided in the Meghalaya pay. There is no pay parity between Assam pay and Meghalaya pay in the same post. Post of Assistant Registrar, being a promotional post, carries a lower pay scale than that of the Superintendent, Stamp Reporter and Stenographer Grade 1. Assam pay scale came into force with effect from 2006, whereas Meghalaya pay scale came into Assam pay scale came into force with effect from 1/1/2006, whereas Meghalaya pay scale came into force with effect from 1/1/2007. Assam pay carries central DNS allowance, while the Meghalaya pay carries the state DNS allowance. To remove the anomalies as expressed by the employees, the High Court of Meghalaya makes the following proposal, namely, number 1, for better pay structure with effect from 23/3/2013 for officers and staff of this registry, proposal as contained at column 5 in the enclosed statement is being made after due examination of the 4th pay revision, where it was found that the officers and the staff of Meghalaya Secretariat Service and Raj Bhavan Secretariat were having better pay scale than that of the officers and staff of this registry. Hence, the proposal has been made to bring about some parity and also further to remove the anomalies as stated above. Number 2, looking into the unique and special service conditions of the officers and staff of Meghalaya High Court, and further to bring about parity to remove the existing dissatisfaction due to stark disparity, and allowance in the form of special pay is proposed to be accorded to all the officers and staff of Meghalaya High Court with effect from 23/3/2013. The special pay so accorded shall be in addition to the respective basic pay. DNS allowances and house rent allowance shall be arrived at after inclusion of the special pay to the respective basic pay. Special pay shall be paid as per the statement below. The above proposal is being made by the Honorable High Court of Meghalaya for better service condition of its service staff. I am therefore directed to request you to place the same before the Governor for his kind approval. Now, my lord, pursuant to this, pursuant to this communication of 2017 by the Registry to the Government, another proposal was, my lord, issued on 12th of August 2017, which is at page 93, page 93, Annexure 5.
By the High Court itself?
Yes, my lord, by the Registry to the State Government in view of the implementation of the 5th Pay Commission, my lord. This is at page 93, Annexure 5, dated 12th of August 2017. So, my lord, with effect from 1st of August 2017, 1st of January 2017, the 5th pay came into effect, my lord. Now, pursuant to this, my lord, the government then, my lord, at page 100, Annexure 6, page 100, Annexure 6, issued an office memorandum, my lord, dated 21st of August 2018, fixing the pay of all the posts in the High Court, my lord.
Yes. 11/21 to 11.
21st August 2018. Upon this office memorandum being issued, my lord, the staff of the High Court immediately made a representation at page 104, my lord, Annexure 7, dated 30th of August 2018, accepting this office memorandum under protest, my lord.
Yes.
Because, my lord, the scale which has been fixed by the state government is one level lower than what has been, my lord, proposed by the Honorable Chief Justice, my lord. So this was accepted under protest. Now, pursuant to this representation at page 104, my lord, at page 105, the registry then forwarded the
resubmitted,
my lord. And again, a reminder on resubmitted on 4th of October 2018, and then a reminder on 26th of June 2019.
Okay, yes, then
along with the
now.
Yes, my lord, along with the
details
proposed, yes, detailed proposed pay scale, my lord. Now, in the meantime, my lord, at page 109 and Annexure 10, my lord, now this new set of rules have been framed and notified, my lord. Now, these rules have been, my lord, framed under clause 2 of Article 229. And this is called, my lord, the High Court of Meghalaya Officers and Staff Recruitment and Conditions of Service Rules 2019. Now, my lord, your lordships will find at Rule 15, that is page 113.
Yes, pay and allowances.
Pay and allowances, my lord. So, my lord, this rule has been framed in line with Article 229, Clause 2, my lord. It reads, my lord, pay and allowances. The scale of pay admissible to persons appointed to various categories of post in the establishment, whether in a substantive or officiating capacity or as a temporary measure, shall be such as may be determined by the Chief Justice from time to time with approval of the Governor. So, my lord, the difference between 2013 rules and 2019 rules is, my lord, 2019 rules clearly provides that approval of the Governor is required, my lord. Now, pursuant to these rules coming to effect, my lord, at page 144, my lord, page 144 and extra 11. The Registrar General, again, my lord, on 4th of October 2019 has issued, my lord, has resubmitted the proposal, my lord, and clearly quoted, my lord, the 2019 rules, my lord, the new rules. If I may read, my lord. Subject reads, my lord, this is dated 4th of October 2019. This is pursuant to the rules being notified, my lord. Subject reads, my lord, resubmission for better pay structure for officers and staff of the High Court of Meghalaya for consideration. It reads, my lord, with reference to the subject and letter under reference, I am directed to inform you that officers and staff of the High Court of Meghalaya have filed representations before the registry on various anomalies that have crept up in their pay. After due proposal by the then Honorable Chief Justice, High Court of Meghalaya, a proposal for better pay structure for officers and staff was submitted to your office via letter dated 13/7/2017. In response, your office has sent the approval of the same via the office memorandum dated 21st of August 2018, which was not in line with proposal of the registry, and the officers and the staff have accepted the proposal under protest. Since then, two communications via dated 4th of October 2018 and 26th of June 2019 was sent to your office in protest to the office memorandum dated 21st of August 2018. Therefore, in continuation to this registry's letter dated 13th of July 2017, and in consideration of the new High Court Meghalaya Officers Staff Recruitment Conditions Service Rules 2019, it is requested to reconsider the office memorandum dated 21st of August 2018 in a matter which will be in line with the pay as approved by the High Court, and to correct the parity in the pay of the employees as appeared in the enclosure who are placed in the same class but are presently drawing different pay level than their counterpart, namely that so and so, my lord. Now, pursuant to this, my lord, government has not taken any action, and again in 2020 at page 146 and exit 12. This is dated 26 February 2020, my lord. The Registrar General again resubmits, my lord, the pay structure to the state government. Now, my lord, despite the several communications and submissions being sent by the registry, my lord, to the government has been sleeping over the issue.
Till now, nothing has been done.
Nothing has been done.
Draft representation was when?
Yes, my lord. Now, again, my lord, we made a representation at page 147 and exit 13.
When was this?
This is, my lord, on 7th of May 2024. Last page 149, your lordships will find the date. This is a joint representation made by, my lord, the staff of the High Court to the Honorable Chief Justice, my lord.
What is an affidavit?
Yes, my lord, I'll just take that to your lordship. Now, pursuant to this representation, my lord, pursuant to this representation, at page 157, my lord, upon the Honorable Chief Justice considering this representation, my lord, a proposal was again sent to the department, my lord. At page 157 and extra 14, this is dated 15th of May 2024. It reads, my lord, with reference to the above, as directed by the Honorable Chief Justice, High Court of Meghalaya, I am furnishing herewith the representation dated 7/5/2024, submitted by the officers and staff of this registry, along with all the enclosures, which is self-explanatory for favor of your kind information and necessary action. Further, I am to state that although the matter has been taken up with the state government as early as 2017, followed by several reminders, the matter appears to have been kept in cold storage, as a result of which the officers and staff of this registry have been deprived of their legitimate rights. Therefore, I would request you to kindly take necessary steps from your end to expedite the matter without any further delay. So, my lord, what the government has done is, my lord, it has slept over the matters, my lord.
Yes, Lord, two issues, my lord. One, whether government has taken on the
My lord, if my lord allows me to complete my arguments, I'll place the law also, my lord, and then the learned advocate general can reply, my lord. Yes, my lord.
Yes.
My lord, the state government has now, my lord, pursuant to this writ petition being filed, state government has filed a reply, my lord. If your lordships kindly have this affidavit dated 28th of February 2025.
Yeah. Yes.
Before that, I'll just take your lordships to my prayer. So, my lord, what they have done in this affidavit is, what they've stated in this affidavit is that the state government is the authority to decide the issue to the exclusion of the governor. If your lordships kindly have
Governor means state government only, yes.
Yes, my lord, but it has to come from the governor, my lord. They say, my lord, at page 9, para 23, they say, my lord, with respect to para 18, at para 23, page 9, with respect to para 18, it is submitted that it is denied that to examine the proposal of the Chief Justice relating to salary of his staff, and the governor grants approval or withholds it, the power to grant approval implies the power to withhold. Then they say at para 24, with respect to para so-and-so, it is submitted that it is denied that the Honorable Chief Justice is the sole authority. They question the authority of the Chief Justice. The Honorable Chief Justice is the sole authority empowered to consider and all matters in relation to pay and allowances of the establishment, which is then subject to approval of governor. It is denied that the state government has no power and role whatsoever in fixation and pay of allowance of the officers and staff of the High Court establishment. Now, what has happened in this matter is, my lord, they have slept over the issue. They have not taken steps, my lord, they have not taken any decisions, neither have they forwarded the proposal, my lord, to the governor, my lord. Now, your lordships, I'll take your lordships the case law, my lord, of various states. But the first judgment I'm relying upon is a judgment, my lord, reported in 1999, volume 3. But this is the case of PD Atri. It is reported in 1999, volume 3, SCC, page 217. The state is also, my lord, relying on this judgment, but I'm also relying on this judgment, my lord. Basically, this judgment says, my lord, that the state cannot sleep over the recommendation of the Chief Justice, my lord. Your lordships, the relevant paragraphs will be paragraphs 7, 8, and 9, my lord. Don't mix up. You mixed up what? We kindly have para 7, my lord. You have the judgment, sir? Yes. You are relying on it?
Yes, sir.
Yes. It reads, my lord, para 7. But then the fact remains that when the Chief Justice of Himachal Pradesh High Court made recommendations to the governor to redesignate, equate the posts of senior translators and junior translators in the Himachal Pradesh High Court to those in the Punjab and Haryana High Court, no decision was communicated, which led to the respondents to approach this honorable court on its judicial side. This is what has happened in this case, my lord. Recommendations of the Chief Justice of the High Court are to be given due deference and utmost consideration by the state government. It certainly cannot sleep over the recommendations. Now, my lord, I'll straight away come to the last line, where it cites, my lord, the case of Supreme Court Employees Welfare Association, which reads, my lord, para 57. So far as the Supreme Court and the High Courts are concerned, the Chief Justice of India and the Chief Justice of the High Court concerned are empowered to frame rules, subject to this, that when the rules are framed by the Chief Justice of India or the Chief Justice of the High Court relating to salaries, allowance, leave or pensions, the approval of the President of India or the Governor, as the case may be, is required. It is apparent that the Chief Justice of India and the Chief Justice of the High Court have been placed at a higher level in regard to the framing of rules containing the condition of service. It is true that the President of India cannot be compelled to grant approval to the rules framed by the Chief Justice of India relating to salaries, allowance, leave or pensions, but it is equally true that when such rules have been framed by a very high dignitary of the state, it should be looked into with respect. And unless there is very good reason not to grant approval, the approval shall always be granted. If the President of India is of the view that the approval cannot be granted, he cannot straightaway refuse to grant such approval. But before doing so, there must be an exchange of thoughts between the President of India and the Chief Justice of India. Para 8. This court in the High Court of Judicature of Rajasthan versus so-and-so, Ramesh Chand Paliwal, restated what a government is expected to do when recommendations are made by the Chief Justice of the High Court in the following words. Para 25. Since under the Constitution, the Chief Justice has also the power to make rules regulating the conditions of service of officers and servants of the High Court, it is obvious that he can also prescribe the scale of salary payable to the particular post. This would also include the power to revise the scale of pay. Since such a rule would involve finances, it has been provided in the Constitution that it will require the approval of the Governor, which in other words means the state. So they're relying on this line. And on this line, they are sleeping over the recommendations, saying we don't want to look into it.
As well as financial implications, or what is the reason? Yes.
This court, even financial implications, they'll have to exchange thoughts. They cannot sleep over it. This court in state of Andhra Pradesh versus so-and-so had expressed the hope that one should accept in the fitness of things and in view of the spirit of Article 229 that the approval ordinarily and generally would be accorded. This was reiterated by this court in Supreme Court Employees Welfare Association versus Union of India. We again reiterate the hope and feel that once the Chief Justice, in the interest of the High Court administration, has taken a progressive step, especially to ameliorate the service conditions of the officers and staff working under him, the state government would hardly raise any objection to the sanction of creation of post or fixation of salary payable for that post or recommendation for revision of scale of pay if the scale of pay of the if the pay of scale of the equivalent post in the government has been revised. Now the last paragraph will be important because this judgment the state is relying on this judgment. But what is the outcome of this judgment? The outcome is at para 9, recommendations of the Chief Justice of the Himachal Pradesh High Court should be considered by the state government having regard to the observation made above and discussion taken at an early date. Now the second judgment I am relying upon
Yes.
Is in the case of Ramesh Chandra Mundra, Milord. This is
20 SSC 163.
Yes, Milord. Reported in 2020, volume 20, SCC page 163, Milord. Now, in this particular matter, Milord, this is with regard to Rajasthan High Court. In this particular matter, the recommendation of the Chief Justice was not referred to the Governor. Now, the relevant paragraphs are, Milord, at page 6, paragraph 6 to 13 and 19 to 20. In this particular case, what had happened, Milord, the state rejected the recommendation of the Chief Justice without forwarding to the Governor. Para 6, Milord. If I may read, Milord. When the matter was heard in this court passed an order directing the state government to put up the matter before the government of Rajasthan, since the proposal of the Chief Justice has not been put up before the Governor. Para 7. It appears that the dissent note of the Finance Secretary of the Government of Rajasthan was put up before the Governor, who has approved the dissent. No reasons have been recorded. So, Milord, even if there is a dissent, Look, there has to be reasons. Para 8. We find that the judgment of the High Court is undoubtedly correct to the extent that it holds that the decision to upgrade any post can be taken only by the Chief Justice, and the said decision cannot be questioned by any authority. Para 9. However, it is clear that the proviso to Article 229, Clause 2 of the Constitution of India, that where any decision of the Chief Justice affects or relates to salaries, allowances, leave and pensions, it would require the approval of the Governor of the state. Article 229 of the Constitution of India does not require a prior approval. Therefore, an ex post facto approval may also be valid. Number 10. We have no doubt that the decision in question of the Chief Justice of the Rajasthan of High Court affected the salaries and allowance which should be payable to the upgraded post. The matter clearly had financial implications which would require the approval of the government of the state. To that extent, the observation of the High Court are not in accordance with Article 229 of the Constitution. Para 11. We however find that the matter has not been properly processed by the state government. In the first instance, the government did not even forward the decision of the Chief Justice for approval to the Governor of the state. They were indeed bound to do so. They merely returned the proposal to the High Court as not acceptable. No reasons was given by the Governor. The present case raises an important question of law, viz. What is the meaning and scope of ambit of the word approval appearing in the proviso to Article 229, Clause 2. Should I take your lordships through the approval part? Then I'll take your lordships straight away to para 19. Para 19. Para 19 reads, on the reading of the Constituent Assembly debates, this is just to summarize what was discussed in previous paragraphs. On reading of the Constituent Assembly debates, it is clear that the real object of the proviso is to ensure that the pay scales between the officers of the constitutional courts and the civil services are kept equal.
Yes.
So, the officers of the constitutional court and the civil servants are to be kept equal. In the present case, this purpose has not been violated. It is not open to the government to reject a proposal which is not in violation of this object. So, as long as the proposal is within the pay scale of which is equal to the civil servants, the government cannot reject it. That is the only ground on which it can reject it. In other words, the only ground for which the government may refuse the proposal of the Chief Justice is that the proposal is not in conformity with the pay scales of the civil services. So this is the only ground on it. Then para 20, it reads, in Supreme Court Employees Welfare Association, it was held that the conditions of service of officers and servants of the Supreme Court in relation to salaries, allowance, so and so, are to be decided by the Chief Justice, and his proposal will ordinarily be accepted by the President. It was held as follows. Now, I won't take your lordship through the entire paragraph, but in the bottom of the page where it's in italic, I'll just read that portion. It reads, the application of mind will include exchange of thoughts. That is application of mind of the government. The application of mind will include exchange of thoughts and views between the government and the Chief Justice of India, and it is highly desirable that there should be a consensus between the two. The rules framed by the Chief Justice of India should normally be accepted by the government, and the question of exchange of thoughts and views will arise only when the government is not in a position to accept the rules relating to salaries and leave pensions. So what it means is, normally the government has to accept the recommendation of the Chief Justice, and if they do not accept the recommendation, then there has to be exchange of thoughts. I'll just take your lordships to the next judgment. Yes, Manoj. Next judgment, Manoj, is reported in 2004, Volume 1, page 334, Manoj. This is, Manoj, High Court Employees Welfare Association, Calcutta, versus State of West Bengal.
There's no judgment, 3-judge bench rules there. 2007 judgment. I don't know, it's here in my file. I don't know who supplied it.
I think that was handed over by the learned AG.
It's my judgment.
2007, volume 3.
But matter was never heard. How was the judgment handed over?
It was partly.
It was not partly heard, my lord. They had not filed the affidavit. Learned AG wanted to make submissions and started handing over the case law, my lord.
That is how.
Then, my lord, your lordships are directing them to first file the affidavit, my lord.
Yes.
So, my lord, the relevant paragraphs is paragraph 10 and 11. Though this matter relates to approval of rules, my lord, but it's important, my lord, if your lordships kindly have para 10 and 11. On this judgment, the Supreme Court, my lord, had remanded the matter back to the government to resolve the same with the High Court. Para 10. Yes. In the instant case, the primary reason for refusal of grant of approval by the governor has been the government's claim of inability to bear the financial burden imposed by the draft rules. The governor under Article 229, Clause 2, has the power to refuse grant of approval, provided there is very good reason. So, there has to be a good reason for the same. It cannot be said that there has been no exchange of views between the Chief Justice and the state government. The correspondence between so and so. Para 11, Lord. The government will have to bear in mind the special nature of the work done by the High Court, which the High Court Chief Justice and his colleagues alone could really appreciate. Then, my lord, this matter was remanded back to the government. Next judgment, my lord, is of Delhi High Court, my lord. It's Supreme Court judgment, my lord, in relation to Delhi High Court staff, my lord. Now, this is reported in 2004, volume 2, page 150. This is a case of SB Vohra, my lord. Para 10 onwards, my lord. Para 10 to 13, if I may read, my lord. Para 10 reads, my lord. The heading is Article 229 of the Constitution. It reads, my lord, Clause 2 of Article 229 of the Constitution of India empowers the Chief Justice of the High Court to prescribe by rules the conditions of service of officers and servants of the High Court. Such rules shall, however, be subject to 1. The provision of any law made by the legislature of the state, and 2. The approval of the President Governor of the state so far as it relates to salary allowances and leave pension. 11. Independence of the High Court is an essential feature for working of the democratic form of government in the country. An absolute control, therefore, has been vested in the High Court over its staff, which could be free from interference from the government, subject, of course, to the limitation imposed by the said provision. There cannot be, however, any doubt whatsoever that while exercising such power of the Chief Justice of the High Court would only be bound by the limitation contained in Clause 2 of Article 229 of the Constitution of India and the proviso appended thereto. Approval of the President / Governor of the state is thus required to be obtained in relation to rules containing provision with regard to salary, allowance, leave and promotion. It is right that such approval should ordinarily be granted as a matter of course. Then, my lord, coming to mandamus, my lord. Mandamus vis-a-vis Article 229. Para 13, my lord. A writ of mandamus is issued in favor of a person who establishes a legal right in himself. I'm raising this point because, my lord, they are also questioning the maintainability of this writ petition, my lord. A writ of on the ground that it's mandamus cannot be issued, my lord, by this court on this issue. It reads, my lord, para 13, a writ of mandamus is issued in favor of a person who establishes a legal right in himself. A writ of mandamus is issued against a person who has a legal duty to perform but has failed or neglected to do so. Such a legal duty emanates from either in the discharge of public duty or by operation of law. My lord, in this case, recommendations were sent and they're sleeping over the recommendations. Your lordships may kindly have para 17, my lord. Again, my lord, para 17, my lord, cites the Supreme Court employees judgment, my lord. And then if your lordships comes to the next page, the second paragraph, my lord.
Judicial review.
Just the one before that, my lord. It starts with, it was further observed in para 50. It is true that the President of India cannot be compelled to grant approval to the rules framed by the Chief Justice of India relating to salaries, allowances, leave or pensions. But it is equally true that when such rules have been framed by a very high dignitary of the state, it should be looked upon with respect, and unless there is very good reason not to grant approval, the approval should always be granted. If the President of India is of the view that the approval cannot be granted, he cannot straightaway refuse to grant such approval, but before doing so, there must be exchange of thoughts between the President of India and the Chief Justice of India. My lord, kindly have para 46, my lord. Before that, para 23, my lord, or 43, where the High Court Employees Welfare Association, State Bengal, has been cited.
That you already cited?
Yes, already cited, my lord. So, para 46, my lord. Decision of this court, as discussed here and above, is in no unmistakable terms suggests that it is a primary duty of the Union of India or the state concerned normally to accept the suggestion made by the holder of a high office like a Chief Justice of a High Court, and differ with this recommendation only in exceptional cases. The reason for differing with the opinion of the holder of such high office must be cogent and sufficient. Even in case of such difference of opinion, the authorities must discuss amongst themselves and try to iron out the differences. The appellant, unfortunately,
the same line.
Yes, on the same line, my lord.
This is
para 51, my lord, towards the end.
Yes.
Yes, my lord. Para 51, conclusion of this judgment, my lord. Having regard to the aforesaid authoritative pronouncements of this court, there cannot be any doubt whatsoever that the recommendation of the Chief Justice should ordinarily be approved by the state, and refusal thereof must be for a strong, equivalent, adequate reason. So this judgment also holds the same. Then the last judgment I have is the Supreme Court Employees Welfare Association. It has been cited in various judgments which I have cited. So, my lord, I'll just point out only, my lord, if your lordships kindly note, I'll just write it down, my lord.
Is this matter still any connected matters is pending for the Supreme Court?
Yes, my lord.
My lord, the issue there are different, my lord.
Yes, my lord.
It's pending.
I have got the writ also, my lord. Supreme Court prayer also and the order also.
Well, those matters are with respect to uniformity in the entire country, my lord. So, my lord, Supreme Court Employees Association, these are the 3 paragraphs, my lord, which I am relying on. Paragraph 46, 57 and 62. Rest, my lord, I'll reply, my lord.
Yes,
yes, my lord.
We'll break now because it's 1:15.
Yes, my lord.
How long will you take?
Your lordship, there are 2 issues, very short 2 issues are there.
Outside it comes other matters.
Yes, my lord, my lord. There are very short issues involved, my lord. What my friend is saying, that the pay scale recommended by state, by the high... only if...
at 2 o'clock.
No, your lordship, only two lines, probably the matter can get resolved also. My lord, what he is saying that in all these judgments, essence is that there should be consultation, my lord, between the high functionaries of the state government and the High Court, my lord, on these matters. Now,
if the governor rejects.
Now he says that only after rejection by the governor. Governor means a state government, my lord. Governor has no independent discretion.
So only one thing we have
so
to see.
We have to hold consultation
only
in
one
this
thing
regard.
we have to see, Mr. Abhi Generals, what steps have you taken? They have repeated representation, there have been recommendations, the rules say so. No. And the thing is that now what what's preventing you?
No, rules.
If at the same level, like out here's level 1 to 21, what I can
Yes, my lord.
gather from here.
Yes,
now,
my lord.
what is the hardship in giving
The
similar
rule-
pay scales to the people doing similar jobs?
No, my lord, there is no issue on
Then
those.
to be
What
parity,
is
why?
what is required is, my lord, that what my friend says, that if whatever is recommended, the state government has no. We wanted to sit and consult and discuss whole discussion on this, my lord. So your lordship may direct that parties to discuss and then place a report before your lordship as to anomalies and all.
First step, my lord.
First, now
First
my
step,
friend
they
is
have to
saying
give
that
rejection.
no,
Yes, my lord.
no rejection. Why should there be
Have
rejection?
you expressed that we are not we will not be unable to agree to this
Your lordship, there has to be
perhaps we can
no, because
revisit
see,
it.
in
There's
these
another
matters, my
meeting.
lord,
Another case coming on
in
Friday,
these
my lord.
matters, my lord, we should not say agree, disagree, my lord. We should sit and discuss and resolve the issue, because
we
these
can't
are
have
the
it that way.
that is the, and your lordship have it in time bound manner. The parties can discuss, and then
No, my lord.
areas of now my friend says no, he wants to resolve the issue, or he wants
Here tomorrow?
I'm here. I will do it. I will do it tomorrow.
You have replies, right?
Oh, yes, my lord. So he wants to
we'll
have.
resume at 2 o'clock for that matter.
My lord, we'll have that. My only issue is that, my lord, all these matters,
No, but
identical
only-
issues.
You've not rejected it. You've not said that no.
Yeah, because I don't want to say. Because why should we say? Because
Then
we can.
you see the things that you can close it. In other words, if you want to send it back for reconsideration.
No, no reconsideration
The
also.
point
No,
is what the
what
governor
we
has to say.
no governor.
Governor
The
has to say
problem is that is a legal problem. He says that governor is bound by the advice of Council of Ministers.
In the other case,
Supreme Court, after judgment of Supreme Court in state of Tamil Nadu, my lord, that argument is also no longer there. There is no independent discretion the governor can exercise in these matters, or any for matter except 356 and Article 200 also. That judgment is also there. But my friend is saying no. You
want to continue at 2 o'clock, or you want to?
We'll have to tomorrow. Tomorrow also there are some matters. Tomorrow we can have it. Tomorrow. But only issue is, my lord, this matter, rather than getting
Embroiled in.
If they should sit whatever areas of difference are there, we will place it and we can see how
come
can.
before the court. I mean,
And we can
unless some a really valid concessions made on the part of the state, then maybe we can pass that direction. Otherwise, if you're stonewalling it like this, what can be seen from the materials, then orders
So,
have
my
to
lord,
follow.
if I can show on the merit also, my lord.
Okay.
On merit also,
We'll
but
hear you on
I
that,
will
of
show
course.
that, and I'll leave it to your lordship thereafter.
Item 34.
The election case, election case, the issues.
Oh.
Yes.
34 and 35 are two writ petitions, Mullah. This is the same blacklisting issue.
You can finish it today?
I will try and do that, Mullah.
Yes,
I don't know
by your guess, I mean, like estimation, how long will you take?
Well, it's definitely not more than 2 hours. So.
2 hours. This is only blacklisting, nothing else.
I know, but just in case, I'll try and be as brief as I can.
Yes.
Well, so the starting point is that we were awarded a contract for two laning of the road from Shillong to a nearby place, Mullets. 1 minute.
Shillong Nonstein.
Nonstein, yeah. It's the road from Shillong to Nonstein. And the date of the contract is 21st February 2011. It was awarded to the petitioner in the first writ petition, which is the JV Mullets. It's a joint venture.
Is that BSPL?
Yes, BSCPL is one
CNC.
and CNC is the other.
Which we are taking up, we think 23.
We take up the writ petition by the joint venture first, Mullets.
That's BSPL, BSCPL.
BSCPL and CNC. That's the
Oh,
JV.
the second one.
BSCPL.
So we'll take that first.
Yes. Yes. So my learned senior would be addressing on the joint venture.
Second.
Second.
So, Mullets, the contract was for 36 months. But there were delays in execution for various reasons, which we need not go into right now, Mullets.
Yes.
But it was successfully completed. On 17th December 2016. And a completion certificate. 15 December 2017, Mullets. The project was completed on 15 December 2017 and a completion certificate was issued on 13th March 2018. Well, these dates are important because we are talking of a project that is already concluded more than 7 years ago. Till date, Mullets, there is no complaint at all on the project per se, that it did not meet the specifications or the road is not proper, nothing. So this is a successful completion of a project way back on 13th March 2018 when the completion certificate was issued. The claims, Mullets, that the petitioners had against the respondent, which is the PWD department of the government of Meghalaya, was first referred to a dispute resolution board, which has nominees of us and them. It's like a mini arbitral tribunal. And our first claim was accepted by the dispute resolution board and they recommended award of that first claim by a decision dated 25th September 2016. So our claim number 1 was actually allowed by this dispute resolution board. And there was an addendum to it on 19th February 2017. Well, it's because they did not pay this amount or the interest that was recommended to be paid. We gave a notice to them invoking arbitration as far as claim 1 is concerned. Well, in the meanwhile, we had a second claim, claim number 2, which again went before the dispute resolution board, and the dispute resolution board number 2 recommended even claim number 2 by its decision dated 25th September 2018. So both our claims were actually recommended for payment by the Dispute Resolution Board, which is the mechanism contemplated under the contract between the parties.
25th September.
Yes, 25th September. Well, naturally, they did not honor either the decision of the Dispute Resolution Board. And so an arbitral tribunal came to be constituted. It was a 3-member arbitral tribunal. And they gave an interim award on 27th July 2021, by which we were awarded 75 crores. This is 27 July 2021. Well, then they started a series of proceedings at the instance of the government of Meghalaya. So they filed a Section 34 application before the commercial court here. And it travelled up to the Supreme Court. I'm cutting a long narration short. Numerous challenges at numerous stages, both before this court and then before the Supreme Court. The Supreme Court finally upheld that interim award by a judgment of 7th August 2023. Their SLP was dismissed. Even at the stage of execution of that interim award, numerous hurdles were raised in courts. And finally, my lords, an execution petition had to be filed. And on 25th January 2024, this date is important. 25th January 2024, they paid us almost 92 crores, that is 75 crores plus interest, which was calculated up to 31/10/2023.
25/1/2024.
This is an important date because we believe that this was the trigger for these present proceedings. Meanwhile, my lords, the mandate of the tribunal was coming to an end because of 29A, Section 29 capital A of the Arbitration Conciliation Act. And they resisted the extension of the mandate by the court. Again, matter travelled up to the Supreme Court. Finally, the commercial court, by an order dated 4th July 2024, extended the mandate of the tribunal till 13/12/2024. Well, it's meanwhile, on 18/7/2024, final arguments commenced before the arbitral tribunal. For the first time, my lords, on 3rd September 2024, the respondent filed a complaint on the basis of which on 10th September 2024 an FIR was registered against the JV and the individual partners of the JV. They then, my lords, on 17th September 2024, we say this is all orchestrated in a certain manner. 10th September, the FIR is registered. On 17th September 2024, they file an application before the tribunal under Section 16, saying that now these disputes are non-arbitrable. This is at the stage of final arguments.
Okay, yes.
The tribunal anyway passed an award on 12th December 2024. It's a 2:1 majority. Claim 1, which has already been awarded to us and paid, that was allowed, that was not disturbed by the tribunal. But the entirety of Claim 2 was rejected. Well, as I'm also going to refer to the award only to the extent it's necessary, because they are blacklisting, they're trying to justify on the basis of the award. Whereas the show cause notice preceding the blacklisting order was issued on No. On 16th September, the show cause notice, which is at Annexure A9,
It's not list of dates.
Yes, was issued on 16 September 2024. It was issued to us, that is the JV, plus the two constituent companies of the JV, that is BSCPL Infrastructure Limited and CNC Construction Limited. The show cause notice was issued on 16 September 2024, whereas the award came about on 12/12/2024. So the award could not be the reason for the show cause notice. This is the point I'm making first, my lords, because a lot of justification in the counter affidavit is on the basis of what the tribunal has observed in its award, which is completely unjustified according to me. We replied to the show cause notice on 30th October 2024, and it is our case that without adverting to the detailed reply given by us, they went ahead and passed the impugned blacklisting order on 13th December 2024. Well, I must just complete the narration as far as the award is concerned. Both of us have now challenged the award before the commercial court. They have challenged the award, the confirmation of claim 1. We have challenged the rejection of claim 2. So both our section 34s are still pending in the commercial court. Meanwhile, in the FIR, my lords, no charge sheet has been filed till date.
Okay.
One of the major planks for the show cause notice is alleged bribery and corruption of government officials by us for getting the contract and for getting extensions of time. What is so significant is, my lords, in the FIR, there is no invocation of the Prevention of Corruption Act.
Okay.
They have only named one former bureaucrat as an accused. And they have not named anyone else. And no charge sheet has till date been filed. This is a significant aspect as far as the FIR is concerned.
No charge sheet till date.
No charge sheet till date.
FIR was filed on 10th.
10th. Registered on 10th on the basis of their complaint. Yeah. 10th September registered.
No.
I must also candidly state, my lords, one of the individual directors of CNC filed a section 482 here, which has been dismissed.
482 is pending.
482 is pending, sorry.
Interim stay.
The application for interim stay there has been dismissed. In that 482, an application for interim stay was asked. I mean, interim stay was sought, it has been rejected by this court by a learned single judge. But the section 482 is still pending here, at the instance of one of the directors of CNC, which is a constituent member of the JV.
One of the employees.
One of the employees, is it?
Who's the named accused?
Okay.
Who's authorized representative in the arbitration?
All right. Now, my lords, if your lordships now comes to the show cause notice, which is the subject matter of the challenge here,
this page?
Annexure P9.
So it's actually part of P56.
Oh,
Part
just give the page number then.
Page number is PDF is 1185.
Is it page 1185? I'm told, my lords.
Well, it's PDF 1185, and on the paper book it is 1145. It is part
Page
of
1145.
Yes, it is part of P56.
But this says Annexure A9.
That is actually.
Oh, I see. Okay, okay. All right. Page 1145, my lords. I'll come to straight away para 5. I'm so sorry.
1145.
Yeah, 1145. I'll come to para.
This was part of it. It's not.
It's a part of another larger document. So
it's part of their application.
Because it's only when they filed an application before the tribunal we.
Was shown as Annexure A9?
Yes, because we got to know of the show cause notice only through their application, and this was enclosed with their application before the tribunal.
Okay, we didn't get it.
We did not actually get a copy. It was not served. This is our case that it was never served on us, this show cause notice.
Yes.
So, your lordship will come to para 5 at the next page, 1146. Whereas Chief Engineer PWD, on behalf of the Government of Meghalaya, entered into the agreement with joint venture on 21/10/2011 for a total contract value of 1303 83,45,181. para 8 is important because they admit, whereas DRB1 made a recommendation on 25th September 2016 for payment of rupees, all these on various heads, 1, 2 and 3, which totals to around 75 crores. It is also relevant to mention here that FIR number so-and-so has been registered on 10/9/24 against you, the addressees, and also against the then Chief Engineer, PWD National Highway, and other officials, persons for various offences committed by you. There's other officials, persons, we still till date don't know who these people are. They have not named them, no charge sheet filed, nothing. Now, the para 9 is a statement of fact. We invoke the dispute resolution mechanism. Para 10 is important. Whereas the DRB2 on 25/9/2018 and subsequent modification order on so-and-so recommended payment of 96 crores 52 lakhs on account of site overheads and head office overheads, rupees 59 crores 20 lakhs towards additional expenses and plant and equipment and all of that. 11 is important, Malats. Whereas the joint venture invoked arbitration proceedings before the arbitral tribunal comprising the 3 members. Now, Malats, para 12 is important. Whereas during the course of arbitration proceedings, instances have come to light from the cross-examination of an official of the joint venture, which culminated on 17/10/2023, showing evidence that bribes have been given by you, the addressees, in respect of instant project to the officials, engineers for obtaining favorable communications letters decision. So this is a cross-examination which culminated on 17/10/2023 in the arbitral proceedings. Para 13, whereas such more glaring instances have come to light in the documents provided by addressee number 3 in its claim before the tribunal, especially under the head of business promotion account at pages so-and-so in documents filed with the statement of claim. Some of them are detailed under. Your Lordships will note that there's 13.1 till 13.17, which is 18 instances of what, according to them, the record is showing, which indicates that these were actually corrupt or fraudulent practice. The aforesaid details leave no scope of doubt. They've already predetermined that you, the addressees, have engaged in corrupt or fraudulent practice in competing have been perpetuated. I don't know what that means. So some typographical error. But they're alleging that these entries show that we have engaged in corrupt or fraudulent practice. Your Lordships will recall that the project was executed between 2011 and 2018, and they're saying all this in 2024, which is 6 years after the entire project has been completed, and they've issued a completion certificate. Whereas clause 37 of instructions to bidders. So this is one provision that they are quoting, and this is in the instructions to bidder. The employer will reject a proposal for award if it determines that the bidder for award has engaged in corrupt or fraudulent practices in competing for the contract in question. I must straight away point out, my lords, these entries which they refer to are not entries pertaining to a period before I submitted a bid. So this clause is, if for getting a bid, I corrupt a government official, then my bid is liable to be rejected. Here we've crossed the stage of bid, we've crossed the stage of contract, completion of contract, completion certificate. So with the greatest respect, this clause is not available to them at all for now blacklisting me 6 years after the contract has been completed. They're trying to underline this: if at any time determines that the firm has engaged in corrupt or fraudulent practice in competing for the contract or in execution. Well, with the greatest respect, this is in the instructions to bidders. This is not the stage at which you invoke it, and not for fraud, not for blacklisting. It is to reject a proposal for award, my lords. They are now trying to justify the blacklisting because they know they can't terminate the contract because it's all over. So this clause is not for blacklisting, with the greatest respect. This is for rejecting a proposal for award, and this is therefore not available to them to be invoked. Now, next clause that they invoke is 59, which the heading itself says termination. The employer or the contractor may terminate the other party if the other party causes a fundamental breach of the contract. It is nobody's case that I've caused any fundamental breach of the contract. At no point have they ever told me that I've committed any breach of the contract. They define fundamental breach in clause B if the contractor, in the judgment of the employer, is engaged in corrupt or fraudulent practices in competing for and in executing the contract. Again, the same thing, Mullahs. So what this clause permits them to do is to terminate a contract, not to blacklist. I think they're forgetting, Mullahs, for blacklisting, because this is a future block on the contractor. It's like a future ban. Hereafter, you will not bid for any of our contracts. And this will have repercussions, because every time I bid for some other contract, I have to disclose that I have been blacklisted. So these two clauses, with the greatest respect, do not give them the power to blacklist me. So the only two clauses quoted in the show cause notice are these two. Now, the above said act of corrupt practice in execution of the project are duly covered under the heading fraudulent practice. And moreover, the employer has a right, even independent of the contract, to initiate blacklisting debarment procedure. With greatest respect, the employer has no such right. In fact, the relationship of employer and contractor goes once a completion certificate has been issued. They can't hark back to a contract to say, I have a right to blacklist you. So this is completely legally flawed, this reasoning they have given in the show cause notice. Now, para 16, they repeat this. Whereas the documents and evidence on record before the tribunal, it appears. So they're trying to prejudge what the tribunal is going to do. It's very significant, my lords. They've already judged because they have suffered an interim award. Their challenge for the interim award failed in the Supreme Court. They resisted the execution. We had at one stage, I did not point that out, my lords, we had to get an order from the executing court attaching their assets. It is only thereafter that they paid. They paid at the pain of contempt. So that this comes after that. So they're now trying to avoid the consequences of what the tribunal might do. Anticipating, they say, documents and evidence on record before the tribunal appears that you, addressees and or officials, engaged in corrupt practice. Unfortunately, I'll point out in the award, my lords, but I can't argue much because our 34 is pending. The tribunal was swayed by what they did before the tribunal. The minute they told the tribunal, we have lodged an FIR, this was in the fag end of the
September 23.
And after the commercial court had extended the time for completion, the tribunal literally, my lords, was intimidated, I would say, into saying, oh, this seems to be a lot of allegations of corruption. So there are 3 or 4 paragraphs in the tribunal's award which was not put to the parties at all. No issue was framed. It is only when we read the final award, we realized that the tribunal has commented on their submissions on our corruption.
Nobody's case.
It was nobody's case. It was not put in issue before the tribunal. And the tribunal has gone ahead and made those comments and rejected my claim too on that basis, my lords. In fact, we are challenging that, saying that this can't be the basis when nothing is put to me in the, my lords, and their cross-examination, if I point out, no questions are asked about corruption. So I read it out last time also, I'll again read it out. So all of this is an afterthought to avoid the inevitable consequence of the arbitral proceedings. So the whole thing is mala fide. They don't have the power under the contract, under any of the clauses of the contract, to blacklist me. The only 2 clauses they have quoted, neither of the clauses are applicable. Once the contract has been completed to the satisfaction of the employer, here the PWD department, they cannot claim to have an independent right. They say that the employer has a right even independent of the contract. There's no such right, with the greatest respect. I have no truck with you. You cannot blacklist me like this, with the greatest respect. And the very basis, my lords, of the show cause notice is evidence before the arbitral tribunal, which the arbitral tribunal is seized of and has come to some conclusion on that basis, which is under challenge in section 34. That untested evidence not commented upon by the arbitral tribunal cannot form the subject matter of your show cause notice. This is overreaching the tribunal anticipating what the tribunal might do. So, my lords, this is sheerly mala fide, it is without application of mind.
And it worked, Timmy.
Yes. They successfully went and dangled that FIR before the tribunal. The tribunal literally got intimidated, saying, oh, this seems to be a huge scam and huge corruption. Third, my lords, this repeated invocation of the word corrupt and fraudulent practice is hollow, because in the FIR, they have not in fact invoked the Prevention of Corruption Act. They've been screaming through the show cause notice and the order of blacklisting that we have committed corruption and fraudulent practice, and their entire counter affidavit is that we've corrupted the officials. And which are these officials? Barring that one ex-engineer of PWD, nobody else has been named. Nobody has been named, and even he is not charged under the PC Act. So they know that they are on a very, very weak legal basis. They are not serious about this repeated invocation of the phrases corruption and fraudulent practice to influence the actions of public officials. So which are these public officials? Well, till date, the FIR is lodged in 12 September 2024. We are in 2025, almost June. Till date, we don't know who these public officials are. So the entire basis of proceeding with this blacklisting is a predetermined basis. It's mala fide. It's without authority of law. And now if your lordship sees the final order of blacklisting, that is Annexure P1. You want me to say something else? Yes, sir. We filed a reply to this. I'm so sorry. We filed a reply to the show cause notice, which is at
1253.
I'm obliged, once. Yes. 30th September 2024. So the first preliminary thing is that we have not received it. I'm going past it now. But para 3 is important. The answering parties state further that the letter and the reply is an exercise of malicious and unscrupulous state power, arbitrary action and rampant misuse of authority, based on mere speculations, half-truths, incomplete records and a deliberate and willful misreading of the documents, wholly out of context, and is completely unfounded on the face of it. Such a mala fide exercise of high-handedness for carrying out a coercive witch hunt through state instrumentality is unprecedented and completely regretful on the part of the state. It follows, therefore, that the letter and the reply is tainted as being a poisonous fruit of such a wrongful exercise of power and does not stand to scrutiny, even in the face of it, and merits instant withdrawal without any further actions warranted against the answering parties. Para 6 is important. During the execution of the contract, there were numerous delays and obstructions caused by the authority, which led to delay in completion of the contract. Because of these delays on the part of the authorities, there had to be multiple extensions of time sought by the BSc and CNC, and which were also granted by the authorities. The delays are on record and have been admitted since even before completion of the contract. Pertinent to note that these were approved, this is important, by the entire department and several officials, not just one or two. Further, since there was an inflation of some items, price escalation was also allowed by the authorities in terms of the contract. It is reiterated that all of this contractual entitlement as per specific terms of the contract was allowed by several officials. It is also pertinent to mention that the department allowing these extensions of time requests for its own defaults and in allowing escalations had also taken the approval of the ministry. My lords, I must point out here, that is next, it is clear and evident that at that time not one, not two, not three, but multiple officials in the state of Meghalaya as well as in the Central Ministry of Road and Transport Highways, MORTH, were involved in the decision-making process. The documents in question would reveal that the government of Meghalaya, PWD, on account of various variations in the extra works, had recommended revised cost estimates from time to time and sought the approval and sanction of the Central Nodal Ministry, that is MORTH. Based on the sanction of the Central Nodal Ministry, the government implemented the said variation revised costs. It is extremely shocking that while in the arbitration proceedings, the state government shifts the entire responsibility of decision making to the Central Nodal Ministry and sought its implemented the arbitration proceedings on that basis. On the other hand, with clear malicious objective, the state government is now accusing the contractor. I must pause here for a minute. This was a project on the National Highway 66A. So MORTH was in the picture, my lords. Unless they cleared the revised estimates, the project would not go through. So what happens is, my lords, MORTH makes the payment and then tells Government of Meghalaya, for this payment we are making pursuant to claim number 1, we will be recovering from what we have to pay you.
Yes.
So that is when they get panicky and they tell the arbitral proceedings tribunal, you have to make MORTH a party. There was a whole round of litigation up to the Supreme Court on this, because the tribunal said MORTH is not a necessary party, the contract is only between you and Government of Meghalaya. So they lost in that. They could not make MORTH a party. Today when they are accusing of corruption, they don't say it's only corruption of government officials of Meghalaya. What they are trying to imply is it could be corruption of even central government.
Okay.
And then it could be corruption of the Dispute Resolution Board, my lords. Your lordships will recall, Dispute Resolution Board, it is their nominee and our nominee. And we choose from their panel. Are you accusing of the DRB1 and DRB2, both of whom allowed my claims? You are accusing them also of corruption. Well, so there is a limit to how much you can go forth with this. This entire show cause notice, therefore, I would say, my lords, is completely malafide. And complete non-application of mine in a contract of this nature when two different ministries have to deal with it, the state government and the central government. And bills are vetted, all estimates are, vetted, not at just the level of Shillong, my lords, but at New Delhi. You can't loosely say we have corrupted all government officials. Who are these government officials that we have corrupted? If Delhi had to pass the revised estimates which I submitted, then clearly you are accusing somebody in MORTH of corruption.
Right.
Do they have the guts to do that? With the greatest respect, my lords, I don't think they have even an idea of what they are talking about. Which is why till date, no charge sheet has been filed. Well, this kind of vague allegation, just, fling it and see where it sticks. Well, it can't be the basis for a blacklisting order, with the greatest respect. So this we've clearly pointed out, and there's no reply to this para 6. No application of mine to this para 6 when I read the final order. 7. Pertinent to note that even during the time these extension of time requests were being granted, BSCV and CNCJV, one of the answering parties, had completely put the authority to notice that because of the delays it had to retain its resources deployed during the extended time, and as a result has suffered additional costs, various losses on account of overhead, plant and equipment, loss of profit and site expenses. The authority agreed and allowed BSC to reserve its rights and claim the same at a later stage. The same is also on record via communications to this effect. And then we point out how we invoked the formal DRB mechanism. And the DRB agreed with us. Para 9 is about DRB 2. And they also agreed with us. Para 12 is important. As far as the claim of DRB 1 is concerned, the tribunal heard both the parties' arguments and considered the claim as well as the response of the authority. The completely contradictory approach of the authority is clear and evident from its responses before the tribunal as well as the authority's case before the tribunal, which was as under. That it was not responsible for the project and only MORTH was responsible for the project. This response was made by the authority's representative via an affidavit, not only before the tribunal but also before the courts thereafter. I am told, my lords, the person who signed the show cause notice is this very person who represented them.
He was a part of one of the officers during the execution of the project.
Anyway.
He also filed the pleadings before the tribunal.
Very well. Well, as this stand is known to this officer who issued the show cause notice, that they were all the time saying MORTH was responsible. It is clear that either the authority's representative put a false case on affidavit before the tribunal and before the courts thereafter, or now is making up a false case to coerce the answering parties. The authority stated that since the claim was undisputed, therefore it could not be taken to arbitration. Once again, it is pointed out with this averment, it is clear that the authority's admission did not merely extend to admissions during the DRB hearing, but also related to admissions prior to DRB hearing and even during the arbitration. This aspect is also noted by the High Court of Meghalaya in an order passed in arbitration appeal so and so. That para 24 of this court's order, what is even more significant is that the appellant herein admitted, the appellant is a PWD, admitted categorically and unequivocally that it had not raised any dispute in respect of the DREB decision of September 25, 2016, as modified and enhanced by the subsequent order of 19th February 2017. In other words, the appellant herein admitted, accepted and acknowledged that it was liable to pay such amount, only that the tribunal could not go into it since there was no dispute in such regard, and as a consequence the matter was not amenable to arbitration or any form of adjudication. In para 33, the High Court provided its views on dispute at large as follows. Here is a case of contract being stretched beyond its original period and payments not being tendered within reasonable time. There was a mechanism which was established in the agreement, and the contractor succeeded by obtaining favourable decisions from the authority that was tasked with such duty to adjudicate such disputes within the framework of the contract. Indeed, there are letters on record which reveal that the contractor offered to give up a substantial part of the amount that had been adjudicated in its favour by the DREB, and even enhance the quantum of rebate, if only to prompt the appellant to making immediate payment. However, the appellant did not relent. And para 37, the real tragedy is not in the appellant as a litigant shying away from payment or its officials being too clever and a half. The tragedy is in the erroneous expert advice that is rendered to the litigants as the appellant. So, we've pointed out all this in our reply and what happened in the commercial court in the section 34 which challenged the claim number 1 award. And para 17.
No allegation.
Yes, no allegation of impropriety can be taken even on the claims which are presently subject matter of the dispute before the tribunal. As we note, the authority and BSc CCJV, one of the answering parties, have differences in disputes of the said claims, and the same will be decided by the tribunal in accordance with law. If the documents mentioned by the authority in paras 12 and 13 have any relevance to the claims, the same will have to be determined by the tribunal in this regard. As far as the claims that have already been awarded to the JV, the same have been allowed by the tribunal and upheld by 3 judicial forums, including the Supreme Court of India, based on the authority's case, and all documents relevant on record, including documents which have been referred by the authority in paras 12 and 13 of the letter and the reply. This is important, else all these documents were already part of the record. They were available with them. In effect, no significance has been attached to the said documents at all at present, and consequently that authorities' averments and allegations in regard are complete afterthoughts and actions of a vengeful state running rampant with its misuse of power. Well, it's para 12, and I may read this a bit slowly. During cross-examination of the arbitration, the authority confronted the witness of the JV with documents which were already in record since 2019. The witness gave his replies, and none of the replies showcase any evidence of alleged bribery or alleged illegal gratification given by any of the answering parties to the official of the authority. It is thus a figment of the authority's imagination and a mere exercise in creative interpretation to state that any instance came to light. The authority is advised to be extremely careful in making loose allegations such as bribes have been given by you, the addressees, in respect of instant project, to the official's engineer for obtaining favourable communications, letters and decision. Well, as I am making good the statement that they have not named any single official to whom a bribe has been given. The authority is bound to clarify as to how the details of the cross-examination show conclusively that bribes were paid for obtaining favourable communication orders. None of this is clear from the evidence taken on the date of 17/10/2023 and amounts to mere speculation and baseless allegation on the part of the authority, seeking only to coerce the answering parties and sensationalize a commercial dispute. The authority is reminded that it does not have the right to make baseless allegations which can affect the goodwill of the answering parties, who are all entities of repute and standing in the country, and in fact have executed a number of large projects of public interest successfully, including project in question. Regarding para 13, these constitute some of the most frivolous allegations made by the authority within the entirety of the letter and reply, and only showcases the authority's desperation to try and threaten and coerce the answering parties. Effectively, the authority is misreading various business-related expenses of the JV and drawing its own conclusions based on narrations in the ledgers. In fact, it is noted with concern that the authority is seeking to term the same as glaring instances, and the authority has already made up its mind to blacklist the answering parties, as is evident by the use of the phrase, "The aforesaid details leave no scope of doubt that you, the addressees, have engaged in corrupt or fraudulent practice in competing have been perpetuated." This amounts to blatant exercise of misinterpretation, obfuscation and mudslinging that has unfortunately been indulged in by a state authority. The instances of the authority's misreading of the entries are glaring. For instance, the authority has sought to link a charitable donation made by the company to some mysterious act of gratification. Although the authority is well aware that the same was made as per the written request from the local administration to assist the local community with accessibility challenges at the Nongkom River. The request was specifically made by the district administration to address the plight of islanders, and being a responsible and concerned company working in the region, the company was pleased to make such donations through check. This act of the local development and charity done at the request of the local administration is now being termed and twisted by the authority in a manner which is reprehensible and does no benefit to the state or the credit of the authority. Certain events organized by the company for which courtesy invitations had been issued to local officials have been deliberately misread by the authority as a sort of illegal gratification. As a matter of fact, even gifts given by the company to its own officials on certain festivals, which are necessary to ensure the morale of the officials towards the project remains unhindered, have been twisted by the authority for nefarious allegations. Certain expenses incurred by the company towards snacks to be served at the meetings for project purposes have been misread and misrepresented by the authority as instances of illegal gratification. The above instances are the most glaring and egregious examples how the authority, having realized that it can be held liable for serious losses incurred by the JV on its account, is now seeking to deflect and divert the issue and make wild and unsubstantiated allegations against the answering parties. The answering parties would have been ready and willing to provide all necessary explanations and supporting documents to the authority had it been any doubts as to the same. However, it appears that the authority has already made up its mind to blacklist the answering parties, as is evident from the use of the terms. The aforesaid details leaves no scope of doubt. It is clear that the authority, which was well aware of these ledgers and all of the answering parties' legitimate business expenses since 2019, chose to remain silent for a full period of 5 years, and has only chosen to raise this at this juncture when the seriousness of the arbitration has dawned upon it. As regards contention in paras 14 and 15, the allegations levelled by the authority are denied in totality. No such act of alleged bribery, corruption, falsification, cheating or forgery have been committed by the answering parties. The reliance of the authority on clauses of the contract, which has already been completed back in 2017, is misconceived and nothing but a desperate measure to try and shift responsibilities of own wrongdoings and non-compliances of the contractual provisions upon the answering parties. It is pertinent to note that the letter and the reply is not only issued belated stage after 7 years after the execution contract, but is also misguided and wrongful. Without prejudice to the above, it is submitted the contract between parties did not even provide for debarment, blacklisting the contractor, and even as per the contract, the only relief for such alleged corrupt fraudulent practice shall in the first instance be notified to the engineer to decide whether such breach caused fundamental breach or not, and so on and so forth. We quote the decisions. Well, now I just wanted to refer to some parts of the record, because this is going to be read, I am sure, by my learned friend.
Yes.
If your Lordship sees, $469. If your Lordship turns to 29th August 2022 cross-examination test, page 474, Malans.
Of this paper book?
Yes. 474.
Yes.
Can I first, let's refer to question 152 for a minute, because it starts with that.
Before that.
Where is that question 152? Do you have it? It must be in some earlier date.
Must be in earlier date.
Yeah, must be an earlier date, Malas. 1 minute. I'll come to that in a minute, Malas, but we can start reading this, because 490.
It's actually down.
490 of Malas. Return to. Yes. Question 152. Kindly see page 3070. Lordship has it? The bottom of page 490. Manas.
Yes.
Kindly see page 3070 of volume 6. What is the business promotion promotedly carried out in connection with the site office for in which an amount of whatever has been claimed for financial year 2014-15? He says, I will check and revert. Now, my lords will come back to page 474.
Yes.
And please see the top of the page.
Have you checked the record?
Yes. Have you checked the record? He says now, to my understanding, business promotion meant in this particular project the additional expenditure that the claimant project office had incurred to handle the local issues in connection with the execution of the project. The classification of expenditure in the project office books of account, however, was not within my domain of scope of works. I have seen such expenses detailed in the ledger statement that are appended at page so and so. Now his attention is drawn to that page 5833. Specifically, entry so and so being cash paid to Chakradar, manager, HR and administration against purchase of wine bottles, 3 numbers, for guests as per instruction. Is it correct that the claimant has categorized the above expense as expense of business promotion, which as per your understanding was meant to handle local issues in connection with the execution of the project? Yes. Classification of expenditure in the project office books of account, however, was not within my domain or scope of works. I put it to you, and this is important, I put it to you that the claimant has included frivolous expenses such as purchase of wine bottles which are unrelated to the project with a view to inflate the claim in the present proceedings. What do you have to say? I deny it. So there's no suggestion that by wine bottles we were trying to bribe anyone else. Today this very thing, entry is being quoted as if it's a clear evidence of bribery. This was their chance to cross-examine. They had these documents from 2019. The only suggestion to the witness is it's a frivolous expense. And this cross-examination was in August 2022. The exact date is 29th August 2022. So how does from 2022, what has changed till 2024, that when they read these answers 2 years later in 2024, it became clear to them this was bribery. So they were desperate to find something. To my understanding, donation carried out, question 227. Donation carried out was under CSR, corporate social responsibility. These were expenses incurred to benefit the local public, included expenses towards medicines to the locals, construction of temporary sheds during winter festival seasons for the benefit of the common public. I must reiterate that the classification of the expenses in the books of accounts was not within my domain of responsibilities. The details expenses are appended. Can you indicate any document from the record in support of your assertion that the expense of donation were carried out under CSR? It is appended at so and so. I put it to you that the purported expenses classified as donation are not project-related expenses and have been included to inflate. This is the line of questioning. Throughout they were saying, this is unconnected to the project. You've claimed all this only to inflate your bills. There was no suggestion in 2022 August that I had bribed anyone. After you have checked the record, can you now answer 179? It is not on the record. Since it is an in-house process of checking, I would like to volunteer. I reiterate the reasonableness is factored in our claim of loss of profits as stated earlier. Our calculations are based on the profit percentages given in the MORTH standard data book, which are well accepted for projects of this nature. Then all this reasonable, well, it's not a single question put to the witness that
it doesn't reflect or reveal any enticement or inducement.
Nothing, not even a vague suggestion, not even the slightest of a hint. So where did they suddenly, on reading all these answers according to them, it dawned on them that there was a clear evidence of bribery and corruption. Whereas I am submitting this is no material at all. This is a case of no evidence as far as bribery and corruption is concerned. That's right. So the only change, my learned friend points out correctly, Manoj, it's at page 727. I adverted to earlier also. The government of India wrote to them at page 727 saying, ultimately you will have to bear this 75 crore payout that's happening to the 75 plus interest, almost 94 crores. Page 727. And now they were desperate how to wriggle out of this. Please see page 727. This is a letter of 22nd December 23. I'm just wondering, Malats, August 2022, this cross-examination happens. Assuming that day it became clear to them in 2022 August that this is all evidence of bribery and corruption, they would have written to MORTH, told them don't release this amount. Without MORTH sanction and the sanction of the President of India. I mean, what is this allegation of bribery now happening, Malats? Against whom? So I am directed to refer to the tribunal award dated so and so and to convey the administrative approval and financial action of the President of India for this 92 crores as interim award of 75 along with 12% interest. The para 2.2 is important. The amount will be recovered from the overall agency charges payable to the state government. So they now knew that this 94 crores is going to be recovered from their agency charges. And the final award is around the corner. If your lordship remembers, they were already resisting the extension of mandate of the tribunal. And the desperation led them to file an FIR. And the FIR then leads to the show cause notice. Please see the sequence, my lords. This letter, the payout happens. Within the payout, within a few months after the payout, complaint, FIR lodged. Within a week of FIR being lodged, produce that FIR before the tribunal. And without telling us that we have issued a show cause notice, quietly enclose it with an application before the tribunal.
Yes.
So the whole sequence is very telltale that this entire exercise is mala fide, predetermined, and so now we come to the impugned order, my lords. Blacklisting order. Lordships will find many more things are now added in the blacklisting order, which were not there in the show cause notice. So now if your lordships comes to the bottom of page 45, actually middle of page 45, my lords. Whereas BSc JV has already filed 16 volumes, which also contains ledgers, vouchers and other documents running into thousands of pages for alleged expenditure incurred by it in the execution of the project. I also want to mention this, my lords. If I was in fact bribing officials, why would I make them part of the ledger? I mean, am I so foolish that I will write in the ledger this is for bribing officials? I mean, there's a limit to how much you can twist what you see as totally illogical, my lords. Illogical, irrational. Whereas upon scrutiny, the voluminous ledgers during the arbitration proceedings in reference to quantification of claim number 2, which pertains to delay, disruption, prolongation of the contract, it was found that various entries interspersed in different pages of the ledger showed clinching material. This is completely vague, my lords. They're not referring to a single page number, a single entry. By now, my lords, this is an order of December 2024. They've sat with these ledgers since 2019. They've completed the cross-examination in 2022. Even now, they're not able to point out a single entry which actually shows there's bribery and corruption. And if such an entry existed, how come they're not invoking the PC Act? And who is the official to whom I have given that such a bribe? What is the amount given as bribe? That is also not indicated. 3 wine bottles can't be the basis of a FIR on bribery and corruption. There were multiple entries of valuable gifts, wine bottles, whiskey bottles, electronic items, food and lodging in the ledger was showing the same very extent to officials. No. These are my own officials, my lords, with the greatest respect. I've already shown in the reply to the show cause notice. I was holding dinners and for morale of my own employees. Where did they get this? This is some government official. And there's not even a suggestion at the cross-examination to the witness that this was given to any government official. Whereas instances have come to light in the documents provided, again, same page 5833 to 5839 of volume 10. This is what I read, my lords, in the cross-examination. These documents were put to the witness at 5833 to 5839, but no suggestion to the witness in the cross-examination that these entries pertain to corruption. Cash being paid for purchase of gift items for government officials. No evidence for this, my lords. They have simply added for government officials. Now your lordships will find that it's a verbatim repetition from 1.1 to 1.7, which means they don't bother with my reply. If your lordship sees 1.15, lordships realizes that this check of 5 lakhs was paid to the non-com We Care Society. This was for the local administration, their request. We explained this, but they're repeating it. They don't care for our explanation, my lords. With the greatest respect, no reference to...
You may have not addressed the show cause at all.
Yes, they have already predetermined. I'm still going ahead and going blacklisting. I'll repeat the entire show cause notice. And they've now added fresh grounds because the entry is now pertain to 2016-17. Just see the bottom of page 46, Mullards. The show cause notice referred only to 15-16. This is important, Mullards. Yep. Whereas business promotion account for financial year 15-16 are also showed expensive liquor, wine have been given to officials regularly. Mullards, who are these officials of the PWD? Even today we don't know. Regularly by BSC for obtaining favourable orders. Which was the favourable order for which such a wine was given or liquor was given? No indication. The ledger filed in the arbitration proceedings also showed incriminating materials indicating that expensive electronic items like Samsung Galaxy tabs, watches have been given to erring officials of PWD. Let them point out if they already know there are erring officials. Who is this erring official of the PhD? It's all in plural, Mullards. Till date we don't know who these officials are. Even an entry dated 25/9/2016, this is not there in the show cause notice. For the financial year 2016-17, not in the show cause notice. At page 8265 in volume 14, filing the arbitration also showed that 13,000 was spent on costly wine. Well, how can this be bribery and corruption? And 6961 in volume 12 also showed laptops were purchased for junior engineers. Even donations have been paid to junior engineers. All this is not there in the show cause notice, Mullards. This entire thing, the last 10 lines, not there in the show cause notice. So you're now relying on material which you don't disclose to me in the show cause notice. I think it's almost a textbook example of how an order can go wrong. All administrative law grounds rely on material, don't put it to the person who's going to be affected by it.
But objective achieved.
Correct. They've successfully thwarted that second claim and now they've sent us into a tizzy now. We'll now be chasing that before the commercial court and then come to the High Court, go up to the Supreme Court. This is endless. And misuse of criminal law, Mullards. It's a sad, very, very sad spectacle. In fact, businessmen are finding it a complete harassment. This is a project completed 7 years ago. Yes. Today I have to wake up 7 years later to answer this kind of frivolous charges of bribery and corruption.
At the same time, your business is affected now.
Completely, Mullards, and they're running to courts. And then you can get all kind of agencies now. Because making allegation is the simplest thing, Mullards. I find on reading all of this and the counter, we are no wiser. When we read the counter, repetition of the same thing. Show cause notice itself becomes counter affidavit. So you don't have to do anything. You just allege. Just say, oh, these entries show me very clear evidence of bribery and corruption. Don't invoke the PC Act. If it's bribery and corruption, how come you don't invoke the PC Act? How come you don't name even one other except one ex-official?
Who's the person who's been named? He's the chief engineer.
Yes, M.R. Sangma.
M.R. Sangma.
For which years he was there?
He was during that period of time when the contract was...
Still it was complete.
2016-17.
And subsequently after proceedings also?
After proceeding for some time, I think.
Not arrested, Mullards. Very important. Not arrested.
Arrest is not required.
Not called for investigation. It's just you have to add somebody there. For government official, you have to add some person. And only one person is added, Mullards, in this entire FIR. I thought by the time this hearing came up, they would come up with at least few more names. They've made no progress. They're not questioning anybody. So where will they file a charge sheet? So this is all for a different purpose, Mullards. This is only to keep us all on tenterhooks. Mullards, then this another big challenge. Whereas the scale of corrupt practice, this second paragraph, can be assessed only by way of thorough criminal investigation.
Where is that?
Second paragraph, page 47. Whereas the scale of corrupt practice can be fully assessed only by way of a thorough criminal investigation which is being carried out. If it can be done only after that, how come you're blacklisting me now? You yourself are admitting that you don't have material. You have not investigated. The possibility, look at this, Mullards, the possibility of unaccounted exchange of money, bribe in the facts of the case cannot be ruled out. But I've never seen a more vague allegation. A contract of 133 crores for execution of the said project has become a contract in excess of 2300 crores on account of alleged delay of 3 years only. Whereas there are 2 DRBs The MORTH has gone over it. It has sanctioned the first claim. You've challenged it any number of times up to the Supreme Court. Over and above, the BSc JV is claiming about 400 crores in arbitral proceedings. It already received about 90 crores approx from the arbitration proceedings on account of wrongful admission. By whom? So this inflation, so-called inflation, is not an inflation with the greatest respect. There were delays. All of this has been explained. It has got the sanction of the President of India after vetting at various levels. And that's how the ultimate contract value had to increase. Now, Malots, we'll see the reply, how they deal with our reply, Malots. Whereas in the reply, please see that, Malots. Whereas in reply dated so-and-so and have miserably failed to answer the charges of overwhelming evidence of corruption and bribery, and made rhetorical statements about general state of affairs. The reply to the show evasive, vague, and failed to reply to the pointed. Well, it's exactly they say the boot is on the other leg. Whereas in reply dated so and so, JV has admitted that they have made such expenses, some of which refer to as expenditure on snacks and expenditure on courtesy visits. The said explanation, see how they're twisting it, Mullah. The said explanation is nothing but an admission of illegal gratification and disingenuous attempt to camouflage the outright corruption. Malas, adjectives are, I think, freely available to them. The corruption cannot be brushed aside on the grounds of delay. However, there is no delay in as much as occasion to examine the ledger entries only arose in 22-23 when witnesses are produced in support of the ledger entries. Further, the stage of final hearing, a closer scrutiny was carried out. This is the mysterious closer scrutiny. Once the central government's letter came, then closer scrutiny. Beyond any pale of doubt. It's so surprising, Mullahs, if the scrutiny was in 22-23, FIR is registered only in September 24. Whereas BSc JV also sought to justify illegal gratification by stating that said gratification will not lead to any favorable outcome in favor of JV, since they had taken a stand that the MORTH is the principal party in the incident project. In other words, it has been claimed that no bribe has been given to MORTH and therefore the charges of corruption are not established. However, the said flimsy excuse is wholly without any basis, as the entire claim is based on alleged admissions in the letter of the then chief engineer and other officials. Moreover, ledger entries filed in the arbitration also show that some money has been paid to MORTH. This is a new thing, Malots. Let them name one MORTH official to whom money has been paid. And for what? For facilitating decisions by the DRB. Well, these are very serious allegations being made under central government officials. I wonder if any state government can get away with this kind of a thing, Malots. You don't have a name of a single MORTH official. You're simply saying money has been paid to them. It's highly irresponsible apart from everything else, Malots. And how am I supposed to defend this? I can't defend this. You don't give me a name of a single MORTH official. Whereas the explanation is also an admission of illegal gratification, as the JV indirectly admits who have extended illegal gratification to officials, but ask for condition. Well, this is all with the greatest respect. I can't answer this. It's so vague. I don't know where they get this from my reply. I read my reply to your lordships. Yes. I don't know how they draw this inference from my reply. Whereas in the contract, although MORTH is the principal party, however, the PW is an agent of MORTH and the illegal gratification extended to officials of PWD cannot be condoned. Well, so apart from the single engineer, Mr. Sangma, they've till date not named any official. Again, they repeat the full scale and extent of fraud and corruption committed by JV and its partners also subject matter of investigation. Then it's all, Malas, again business ledgers and all that. In view thereof, it is concluded. So, Malas, all that I have set out in my reply, for instance, I have said these two clauses can't apply at all. You have no power to blacklist me. They don't answer that. They again say, whereas the instruction to bidders, please see that second line, page 49, specifically prohibits acts of corruption and fraudulent practice.
Yes.
In view thereof, it is concluded and so have committed acts of bribery, corruption, fraud and cheating during the execution of the contract. and is hereby blacklisted, debarred from practicing any future tender contracts for a period of 5 years. Well, so the greatest respect, I submit that this order suffers from numerous illegalities. One is, it's completely malicious. It's an exercise, a classic textbook example of malice in law, where without any authority, you proceed to blacklist a contractor in a contract for which a completion certificate was issued way back in 2018. That is 6 years prior to the issuance of the show cause notice. Second, my lords, it's entirely based on unfounded, vague and unspecified allegations. Third, it is purportedly based on some evidence before an arbitral tribunal, which evidence in fact does not indicate any bribery or corruption, even if you read it 10 times over. Fourth, my lords, it's an afterthought. The entire exercise is an afterthought to avoid the consequences of an arbitral award against them. Fifth, my lords, the reply given by me has not even been appreciated, has been misinterpreted. Sixth, in the final order blacklisting me, they've relied on material which was not put to me in the show cause notice. This is extraneous material for which I had no opportunity to answer. Seventh, although the allegation is of bribery, corruption, in the FIR filed till date, there is no invocation of the Prevention of Corruption Act. Second, except one retired official of the PWD, Mr. Sangma, not a single official has been named, government official has been named, to whom alleged bribes were given. Well, it's even more serious. Eighth, they have now made a frontal allegation in the final order that we gave money to MORTH officials. This was not there in the show cause notice, with the greatest respect, my lords. Now they've slipped in that money has been paid to MORTH officials for facilitating decisions by the DRB. This is a very, very serious allegation, because DRB has very highly reputed people on the panel, and some of them are former government servants. They are not even serving government servants. To loosely allege that DRB officials could be bribed without indicating to which of those officials any bribe was paid is a very, very serious matter.
We'll just limit it to, the power, whether, under the 3759, whether it flows from there.
That's right.
With regard to the action that they've taken, and whether, and then consequently, I think we can limit it to that.
Because one attempt,
warrants,
yeah, because I have to say this because I know where I've read the reply. I just want to point out, because I know this will deflect somewhere else.
Preempting the reply.
Because the reply deflects completely different direction. First of all, Malas, in the reply, let me straight away deal with that, because I'm sure my learned friend will begin with that. In my writ petition, at para 5.1, I say, well, it's para 5.1 of my writ petition, page 5. The petitioner is a joint venture between BSCPL Infrastructure Private Limited and CNC Construction Limited.
Yes.
And bracket F says CNC Construction has now been liquidated. This I needed to clarify. According to them, I have suppressed a material fact that CNC was under liquidation. In fact, I have not suppressed it. I have actually mentioned that it's liquidated. But the correct fact is this, and I should make this clear. CNC went into liquidation. There was a CIRP process initiated. But while it was under liquidation and with no bidders coming in, they decided to go in for selling it as a going concern. So, my lords, on 2 dates, if your lordships will just note it down, the assets of CNC were sold to 2 bidders on 2 separate dates. One of the buyers is one RK Construction, and the other is Tavasya.
Is it here in the petition? No.
No, I have the, with the rejoinder, I've placed some of those documents, my lords. If your lordship sees my rejoinder, which is the page of the rejoinder, the paragraph and then page. First paragraph. No, first paragraph. Page 3. Lordship turns to page 3 of the rejoinder. If Lordship turns to para 1.1.3, it may be noted that by this time the project in question was completed and the parties were already in arbitration proceedings. It is after BSEPL had taken over the management of the JV solely, the CNC construction went into insolvency. Well, as this JV, your Lordships will note that BSEPL is now 93% and CNC is only about 7%. They have internally arranged that BSEPL will take over the entire conduct of the arbitration proceedings, but the JV is very much there. The insolvency process of CNC was initiated by order of the NCLT. So and so, pursuant to this order, the interim resolution professional was appointed, and so and so. Now, para 1.15, my lords. It is pertinent to note that following the scheme of the IBC and liquidation order, the liquidator conducted multiple rounds of sale auction. However, the assets of company could not be sold. It is only during the 13th and 14th round of auction that one company named Tavasya and RK Constructions were declared successful bidders. So the assets of CNC have been sold to Tavasya and RK Construction. Thereafter, sales certificate so-and-so was finalized and CNC was successfully sold as a going concern. This has been confirmed as a liquidator. But the correct position is this, my lords. While the assets have been sold to these two companies, CNC Construction remains and it is part of the JV. So a red herring is sought to be, put forth.
You mean to say that although the assets have been sold, it's an ongoing concern?
It's still a concern, my lords, because although the assets,
how is that possible?
My lords, they still have the JV. They are still partners of the JV. As CNC Construction, they are partners of the JV. If I may just show you, Lordships, the annexure to this rejoinder, your Lordships will understand it. Which is that annexure? Annexure 2 to the rejoinder, if Lordship sees it. It's under the letterhead of CNC Constructions Limited.
Yes.
Important announcement. The company is under liquidation via NCLT order dated so and so. The company has been sold as a going concern through the 14th auction for a total sale consideration of 104 crores. This is in addition to the sale of investment block made in the 13th round. The total sale consideration is so and so. The liquidator has received the entire sale consideration from both the 13th and 14th. The liquidator already issued a sales certificate and has now issued sales certificate to the 14th auction purchaser. So, Malas, we have both those certificates. What those certificates show is the assets have been sold. If I may hand over that, Malas. But if Lordships appreciates, under the Companies Act, until a company is struck off from the register of companies, it still exists. You already given. Yes, Lordships will see that.
But can still function?
Yes, the company is still very much there and it has shares in the JV. It has a 7% share in the JV, whereas the BSEPL has 93% shares.
See, so the company has been sold as a going concern.
Please, my lords. That's what I tried to understand. I sat with them.
You'll have to explain that to us also.
Yes, my lords. I can file a separate affidavit. In fact, I was telling them we'll file a separate affidavit.
I think because that's
yes, we will file a separate affidavit. We'll give you the entire sequence. Because in law, my lords, although this is loosely used saying the company is sold, the shares of the company are not sold, my lords. It's the assets of the company that have been sold. The company exists as an entity. Its assets may have been sold to recover the monies that it owed to its creditors. But it has still a company with shareholding and it's still part of the JV. So, Malas, the point they are making is that there is no JV today, which is not correct.
That we have to address.
Yes. There is a JV. It's only that shareholding of BSEPL is 93% and CNC is 7%. Where is that letter?
So, question: any other of these two entities stepping into the shoes of CNC?
No, doesn't arise. Doesn't arise. And there is no dispute inter se between the JV partners. They say without the consent of CNC, how could you have pursued this arbitration? There's no question of that at all because of a letter. Give me that letter, please.
This one?
No. The BSEPL will conduct the entire litigation.
Sir, this one. Here at the end.
No. There was a letter inter se, say BSEPL and CNC, saying we will now take over the litigation.
So that is Annexure 1.
Annexure 1 to the rejoinder, if your Lordship sees. Annexure 1 to the rejoinder.
Yes, this is. Yes.
The last part, for the benefit of understanding between the partners, BSCPL will have the following rights on the invocation of clause 23. That is in their agreement. BSCPL will solely have the authority for all approvals, including bank operations under clause so and so. The operations with JV bank accounts as specified shall cancel till such time all obligations are met for the completion of the projects. BSCPL shall entitle for all receivables, including claims to make payments, complete obligations of the contract. BSCPL is entitled to get the indemnify from CNC to make itself secure from the liabilities of CNC for any failures of non-performance. BSCPL shall have the priority to recover excess contribution. BSC shall have the right to retain completion of work of all assets. So this is co-signed by both of them. That is BSCPL on the left and CNC on the right. It's acknowledged, and this was way back in 10/1/2019. The date of this letter is 10/1/2019. This is after the project was completed, when the arbitrations were going on. So we did not do it behind the back of CNC as is being alleged. And at this stage, the CNC had not gone into liquidation. So there was no question of an IRP being told and his permission being sought. All that didn't arise at all. Which is why, Malas, they're somehow projecting facts which are not full-fledged facts. We have to bring this letter on record.
We have to understand that.
That's right. We have to understand. I'm obliged. We have to understand. So we can file an additional affidavit only on this aspect as to what happened between this 10/1/2019 till date. The point I want to make is this. Yeah.
What is your status? What is your,
JV continues, my lords. It's only our respective percentages that have changed. We are 93%, they are 7%. So that again is part of this.
We have just handed over the independent auditor's report.
We'll place it. I thought we'll place it with an affidavit.
That will be an affidavit.
Yeah. Yes.
You can't take it.
Indicates a shareholding pattern.
But if that's a very relevant point which you have raised.
No, but the point really is this. It's actually a deflection I would respectfully submit. Because they are now, treating the JV as a JV. Because they issued show cause notice to the JV. They've blacklisted the JV.
Yes.
If according to them there is no JV, then whom are they issuing show cause notice to? Whom are they blacklisting? They have to make up their mind. We are clear that the JV exists. But if today it is their case that there is no JV, there is no question of blacklisting. Best is for them to make a statement saying that now that we believe there is no JV, we are withdrawing our show cause notice against the JV. They will not do it. They will obviously not do it.
They are pursuing remedies, and the arbitration remedies are pursuing, so they can't recall that also.
That's right. That's right. So, they can't have it both ways. They can't say there is no JV, and they can't say, no, I will persist with my show cause notice against the JV. They'll have to make up the mind. So, the JV does exist. Factually, the JV does exist. CNC does exist. There was no question of not taking permission of CNC. There was a clear understanding that we would take over all the task of recovering dues to the JV. And we made it clear in that letter, which is Annexure 1 to the rejoinder. And although CNC's assets have been sold, CNC as an entity continues. And so the JV continues. I think this will be actually...
has been, as an ongoing concern.
Yes.
That's the only thing.
That's right. So, it's a legal...
has been sold as an ongoing concern.
No, the shares are not sold, which is why I repeatedly asked them, are the shares of a company sold? Sometimes shares are bought over. And then once you take over the shares, you are a majority shareholder of that company, then automatically you are in control of the company. But this is not how it happens. When you sell as a going concern, you sell the assets. The shareholding pattern doesn't change. The shareholding of that CNC construction remains as it is. Anyway, we will cross-verify it, we'll check it, we'll file an affidavit. But what I want to leave your lordships with is this. There is no question of there being no JV. There's no question of us pursuing this litigation behind the back of CNC as is being made out. There's no question of these two purchasers in the auction stepping into the shoes of CNC. They have nothing to do, both the sales certificates say they have nothing to do with ongoing arbitrations or claims. They're clearly excluded.
That's positive.
Yes. And the sales certificate clearly say what is excluded, what is included. So that makes it abundantly clear that this arbitration, recovery, all that is not...
Sales certificate is not on record by affidavit?
No, not with an affidavit, but...
One sales certificate is there, the other we have...
One I've handed over, CNC Constructions.
We have handed over this one.
Your lordship sees a sales certificate. Just to give you an example,
yes.
Description of sale assets, Schedule A.
Yes.
You will see A4, arbitration claims of CNC Construction Limited on standalone basis. Only that is sold. Not arbitration claims which are pertaining to JVs. Please see the exclusions. Next page, last page. Bullet point 3, exclusions. Arbitration claims pertaining to subsidiaries JVs.
Okay.
That's not sold. Because that is still being pursued here. In our inter se understanding of 2019, we were to take, because recovery of these claims also means investing monies. And CNC didn't have the means. They were in a bad way, so we had to take over this entire task of recovering monies. Because under claim 2, I think it's 200 crore plus. 313 crores under claim 2. So unless we spend money through litigation, and these people will drag us to litigation, God knows to how many more courts. There's no end. I think good news for lawyers, but bad news for parties. So that's the reality of the situation. So we want to place this entire thing, we'll place it with an affidavit.
Yeah, let's be clear. That's a pointed objection that they've taken.
Yes. And I don't know how it justifies blacklisting anyway, my lords. How does all this justify? That's why I'm saying it's a deflection. The show cause notice is not, oh, you have not informed CNC and therefore I'm blacklisting you. That's not the show cause notice.
So even if the court passes, the orders have to be against the right parties. That's what I'm
Correct.
concerned.
Correct.
That's the only thing.
That's right,
if
my
the
lords.
other parties were already, we're thinking.
No, in fact, CNC. CNC
whether
itself.
There should be parties here at all. But the exclusion agreement says that. So they'll be out of this entire picture.
No. CNC is very much a party to these proceedings.
Very much, but I mean the new people have come. I mean the new entities who have bought over the assets.
But they have not become shareholders of CNC. No. They have not become part of shareholders. They're not part of CNC. They've only taken over these assets and only some of the assets. That's why the enclosure to this is important. We'll explain that once. We'll explain that in an affidavit. So barring that only thing, all this, with the greatest respect, has nothing to do with blacklisting. This is not the ground for blacklisting. This is not there in the show cause notice saying, oh, one of your partners went to the liquidation. And third, most important, it's not they were unaware of all this. They were aware of the liquidation proceedings that CNC was facing, even in the arbitral proceedings.
Okay.
Yeah. Correct. On the second writ petition by BSCPL, this is all not relevant, ballots. Yes. It's only the JV which has to explain what has happened with CNC.
So, second one's only on a core issue.
BSCPL, we have been dragged along. There's not even a whisper, no particularization. What really happened, which official of BSCPL was involved, there's nothing of that sort.
Yes.
So, this affidavit, we'll file it before the next date. If learned friend finishes today, then I don't know.
Today, though, I won't. Your argument is over, sir. Your argument is concluded. So then
we've got,
only the case law, Eurasian is one which we cite always.
All the time, yes.
Yeah. And there's one more judgment. There are 3 judgments actually, which I am referring to. I'll just give you the citations. I don't even have to read them. Well, so apart from Eurasian, there's UMC Technologies Private Limited versus Food Corporation of India.
Yes.
2021. And the relevant para is para 14.
Yes, sir. Judgments.
Yeah, right. Para 14, Malots. Yeah. Yeah, it's okay. Para 13 also, Malots. Actually, para 13. At the outset, it must be noted that it is the first principle of civilized jurisprudence that a person against whom any action is sought to be taken or whose right or interests are being affected should be given a reasonable opportunity to defend himself. The basic principle of natural justice is that before adjudication starts, the authority concerned should give the affected party a notice of the case against him so that he can defend himself. Such notice should be adequate and the grounds necessitating action and the penalty action proposed should be mentioned specifically and unambiguously. These 2 words I want to emphasize, specifically and unambiguously. An order travelling beyond the bounds of notice is impermissible and without jurisdiction. I have pointed out to your lordships how the final order adverted to facts which were not mentioned in the first show cause notice at all. Para 14. In Nazir Ahmed, it was held that essential for the notice to specify the particular grounds on the basis of which an action is proposed to be taken so as to enable the noticees to answer the case against him. If these conditions are not satisfied, the person cannot be said to have been granted any reasonable opportunity of being heard. 14. Specifically in the context of blacklisting of a person or an entity by a state or state corporation, the requirement of a valid, particularized and unambiguous show cause notice is particularly crucial due to the severe consequences of blacklisting and the stigmatization that accrues to the person, entity being blacklisted. Here it may be gainful to describe the concept of blacklisting and the graveness of the consequences occasioned by it. Blacklisting has the effect of denying a person or an entity the privileged opportunity of entering into governmental contracts. This privilege arises because it is the state who is the counterparty in government contracts, and as such, every eligible person is to be afforded an equal opportunity to participate in such contracts without arbitrariness and discrimination. Not only does blacklisting take away this privilege, it also tarnishes the blacklisted person's reputation and brings the person's character into question. Blacklisting also has long-lasting civil consequences for the future business prospects of the blacklisted person. So, para 13, specifically and unambiguously, I want to highlight that. And in para 14, particularized and unambiguous show cause notice. This is extremely important because the show cause notice here lacks specific particulars and does not deal with my reply. The final order blacklisting adverts to facts which are not stated in the show cause notice and adds further allegations about bribing MORTH officials and even DRB members. Well, the other judgment is Eurasian equipment. Although, my lords, it's been cited often. Paras 15 and 16. Para 15. The blacklisting order does not pertain to any particular contract. The blacklisting order involves civil consequences, casts a slur, it creates a barrier between the persons blacklisted and the government in the matter of transactions. The blacklists are instruments of coercion. In passing an order of blacklisting, the government department acts what is described as a standardized code. This is a code for internal instruction. The government departments make regular purchases. They maintain list of approved suppliers after taking into account the financial standard of the firm, their capacity and their past performance. The removal from the list is made for various reasons. The grounds on which blacklisting may be ordered are if the proprietor of the firm is convicted by a court of law or security considerations to warrant, or if there is any strong justification of believing that the proprietor or employee of the firm has been guilty of malpractices such as bribery, corruption, fraud, or if the firm continuously refuses to return government dues, or if the firm employs a government servant dismissed or removed on account of corruption in a position where he could corrupt government servants. The petitioner was blacklisted on the ground of believing that the firm has been guilty of malpractices such as bribery, corruption, fraud, so and so. 17 is important. The government is a government of laws and not of men. It is true that neither the petitioner nor the respondent has any right to enter into a contract, but they are entitled to equal treatment with others who offer tender or quotations for the purchase of goods. This privilege arises because it is the government which is trading with the public, and the democratic form of government demands equality and absence of arbitrariness and discrimination in such transactions. Hofield, Malots, I'll skip that. 19, para 19, Malots. Where the state is dealing with individuals in transactions of sales and purchases of goods, the two important factors are that the individual is entitled to trade with the government and an individual is entitled to a fair and equal treatment with others. A duty to act fairly can be interpreted as a meaning a duty to observe certain aspects of rules of natural justice. A body may be under a duty to give a fair consideration to the facts and to consider the representations, but not to disclose to those persons details of information in its possession. Sometimes duty to act fairly can also be sustained without providing an opportunity for oral hearing. It will depend on the nature and the interest to be affected, the circumstance which a power is exercised, nature of the sanctions involved therein. Blacklisting has the effect of preventing a person from privilege and advantage of entering into lawful relations with the government for the purpose of gains. The fact that a disability is created by the order of blacklisting indicates the relevant authorities to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to represent his case before he is put on the blacklist. This was further explained in that other case where about particularized and allegations not having to be vague. Which is the other one? Prakash Atlanta. No. Gorka Security. Well, the other decision is Gorka Security Services versus Government of NCT of Delhi, 2014, 9 SCC 105. But this is again the reiteration of the same principles. Para 28 and 29 are important ones in this. Paras 28 and 29. Because here again the allegations are vague, and that's how the court interfered. And there must be a specific power to backlist that this judgment emphasizes. If there is no such power to do it, then the entire action will be illegal. And natural justice is, of course, emphasized everywhere.
Yes.
Well,
I think that will do it.
Yes, sir.
Only reply.
Yes, my lord. I can start, my lord, or your lordship may have it some other day.
Yes.
Your lordship may have it on 5th of my reply.
5th June? Can you excuse me from June because that's the vacation? Amit has shifted here, so he follows the calendar.
He doesn't have any holidays.
The holidays, that is the biggest problem which I face.
You take a date and then because we have, I think, submissions of the senior council.
Can we have it in the last week of June?
I'm not here.
I'm so sorry. I'm so sorry.
You take your date.
Well, we'll just sit and we'll.
Yes.
Very well. We'll file the affidavit before that. Yeah.
Yes, just for the record.
That's right. All those documents will place.
Otherwise, yes.
Yes.
I don't want to leave any local.
Right. Right.
Thank you.
Grateful.
You're going well.
I need to leave.